Welcome, everyone, to the Hillsborough Township Planning Board meeting of November 9th, 2023. Please join me in a salute to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be advised this meeting has been duly advertised according to Section 5 of the Open Publics Meeting Act, Chapter 231, Public Law 1975, otherwise known as the Sunshine Law. Notice of 2023 annual meeting schedule and amended meeting dates have been provided to the officially designated newspapers, the township clerk, posted on the township's website, and available here at the Hillsborough Township Municipal Complex. In addition, application documents have been made available on the Township Civic Clerk website, and complete application files are available in the Planning and Zoning Department for inspections in accordance with the public meeting notice. With that, may I have a roll call of board members and also board and township professionals, please?
Vice Chair Julian, Committeeman Ciccarelli, Mr. Wagner, and currently Mr. Delcor are absent. Mr. Peason?
Here.
Mr. Scobo?
Here.
Ms. Smith?
Here.
Mr. Radowitz?
Here.
Mayor Lapani?
Here.
Chair Saraji?
Here.
Mr. Coyce?
Here.
Mr. Bernstein?
Here.
Mr. Hay?
Here.
Mr. Carr?
Here.
And the videographer and myself are here.
Okay, welcome, everyone. So we have some meeting minutes for consideration. First up, April 13th, 2023, regular meeting minutes. Mr. Bernstein?
Mr. Chairman, the eligible members are Mr. Peason, Mr. Scobo, Ms. Smith, Mr. Radowitz. Actually, everybody on the dais is eligible.
Okay,
I'll make a
Thank-
motion, Mr. Chairman.
thank you, Mr. And we have a second. Any comments from the dais? Hearing none, roll call, please.
Mr. Peason?
Yes.
Mr. Scobo?
Yes.
Ms. Smith?
Yes.
Mr. Radowitz? Mayor Lapani?
Yes.
Chair Saraji?
Yes. Next, meeting minutes of May 11th, 2023.
Eligible members, Mr. Chairman, are Mr. Scobo, Ms. Smith, the mayor, and yourself.
Thank you. May I have a motion to
I'll
approve?
make that motion.
Second.
It was a tie.
You're not eligible, Mr. Peason.
Nope.
Then the mayor has the
Nice
second.
try.
I will second. Mayor seconds.
Okay, comments from the dais? Hearing none, roll call, please.
Mr. Scobo?
Yes.
Ms. Smith?
Yes.
Mayor Lapani?
Yes.
Chair Saraji?
Yes. Next, May 25th, 2023.
Mr. Peason, actually, everybody on the dais except Mr. Radowitz.
Okay, we have a motion.
I'll make that motion.
I'll second.
There we go. Comments?
Yes.
Bob?
Hearing none, roll call, please.
Mr. Peason?
Yes.
Mr. Scobo?
Yes.
Ms. Smith?
Yes.
Mayor Lapani?
Yes.
Chair Saraji?
Yes. Next up, June 8th, 2023, meeting minutes.
Same as May 25th, everyone but Mr. Radowitz.
Is there a motion?
I'll make that motion. Second.
Okay, the mayor has the second.
Somebody else. Yep.
Comments? Hearing none, roll call, please.
Mr. Peason?
Yes.
Mr. Scobo? Ms.
Yes.
Smith?
Yes.
Mayor Lapani?
Yes.
Chair Saraji?
Yes. We do not have any resolutions for consideration, no ordinances for consideration, and no planning board business. So now we will move to business from the floor for matters that are not on this evening's agenda. Okay, no one is coming up, so we are going to move on to tonight's application, public hearing, Royce Brook Golf LLC with a file number of file number 23-PB-04-RES with the time of decision, 12/31/23. The application is continuing from the July 20th, 2023 meeting without further notice.
Before Mr. Linus, Mr. Chairman, places himself on the record, Mr. Scobo, I believe, is recusing himself from this application.
That's correct. Thank you.
Okay, so he will leave the dais. I'd also like to place on the record, and a very important item from Mr. Linus and his client, certification of absent board member, examination of record eligibility to vote, signed by Mr. Peason relative to the viewing of the video recording of July 20th. We therefore provide for a quorum for this application.
So Lennis.
Yes, thank you very much, Mr. Chairman, members of the Planning Board, members of the public. My name is Francis P. Linus. My offices are located in Somerset, New Jersey. I'm pleased to represent Roycebrook Golf LLC tonight. As the board may recall, the last time we met was a few months ago, July 20th, to be exact. At that meeting, I'd like to recap and provide an overview of what we expect to accomplish tonight. As the board may recall, this is the application of Roycebrook Golf, and basically we're here on a 1994 resolution. We're looking for a modification and clarification of some of the conditions relating to that resolution and the attendant testing that had occurred. As the board may recall, we presented one witness at that time, Dan Latanzi, an LSRP, which is a licensed site remedial professional who represents and has been contracted with by Roycebrook, as well as Toll Brothers, did some work for Toll Brothers as well. So basically, we're here tonight to continue with that testimony. Where we left off, we had some questions that the board wanted answers to. In response to that, we've submitted documentation, additional reports from Mr. Latanzi, and additional information. So we are ready to proceed. I expect to have one witness tonight, although we do have a representative of Roycebrook in case the board or public has any questions that are not answered by Mr. Latanzi. So having said that, I have some exhibits. Should I pre-mark them, Mr. Bernstein, or just as we go along?
Why don't we go along?
Okay, very good. All right, my first witness and only witness is Dan Latanzi. Dan, you understand you remain under oath?
I do.
Why don't we just swear?
We're just going to
Sure.
swear him back in.
Give Mr. Lombardozzi something.
Let me stand up. I do, or I will. I will give the, would you like me to say? Sure. Daniel Latanzi, last name Lattanzi.
All right, Dan, at the last hearing, you alluded to the fact that you're an LSRP. Do you want to explain to the board and the public who are here what an LSRP is and what statutory obligations you have as an LSRP?
Sure. Like Frank said, an LSRP, or licensed site remediation professional, is a licensed professional in the state of New Jersey that's required to oversee any remediation or investigation for the DEP. The Site Remediation Reform Act was enacted in May of 2012. Basically, that shifted the responsibility of an oversight of remediation from the New Jersey Department of Environmental Protection to an LSRP. So as a licensed professional, we have to understand the technical requirements that the DEP sets forth, various guidance documents to ensure that the environment and human health is being protected. So this includes conducting investigations, sample collection, review of data, working with laboratories on various report submittals, submitting remedial phase documents to the state for review, and ultimately submitting what's called a response action outcome for cases that are open with the department. If you may be aware of the no further action letter, that's now been replaced by what's called the response action outcome. But similar to any other licensed professional, we have code of conduct that we need to follow and that must be adhered to. And documents must be sufficient to submittal to the state to make sure that all work's being completed in accordance with requirements.
Right. Can you lose your license?
Yes.
Under what circumstances?
Certainly falsifying data, doing any actions that are unbecoming of a licensed professional. There, like I said before, there is a code of conduct that all LSRPs must follow. We are trained on this. There are additional courses that an LSRP must continue to attend to make sure that you're up to date on all the regulations, and also with your code of conduct and ethics to make sure that the work is done correctly and accurately and under your license. So yes, that can happen.
Okay, before we get into the details of what you've done since the last meeting, do you want to make a statement?
Yes, so as an LSRP, I've managed over 100 cases in New Jersey. That includes former and current golf courses in New Jersey, including Roycebrook Golf Course, as Frank alluded to. I first started working on this site in 2017, and when Roycebrook became aware of the 1994 resolution, they hired my former company, First Environment, to begin testing in accordance with that resolution. That testing continued from late 2019 up until currently October of 2023. I should say, too, Frank wanted me to mention this, I'm no longer with First Environment. Since the last meeting, I've moved to a new company called Delta Environmental Services. So if you see Delta on there, it's still me. Still the same people behind the scenes doing the work, it's just a different company name. But overall, since 2019 through now, we've collected several rounds of data from multiple media, groundwater, surface water, soil. We've done the work in accordance with DEP requirements and in accordance with guidance that's presented to an LSRP. Overwhelmingly, the data that we've collected to date has shown that the golf course operations have not impacted any environmental media on or adjacent to the property. Like I said before, I personally have worked on other golf courses that typically deal with pesticide applications, of course, to manicure and take care of a golf course. We are obviously sensitive to making sure that these chemicals do not impact the environment or to anyone's human health. But again, over years and years of data that we've collected, multiple samples and lab tests, I have not seen any evidence to suggest the golf course has impacted the environment.
Okay, at the last meeting, I made a representation, which is not evidence, that since Royce Brook Golf Club took possession of the property by virtue of a deed in 2007, there was a gap in terms of the testing that was not done between 2007 and I guess 2021. What can you tell the board and the public regarding that gap?
Well, that's where, like I said before, that's where my company, First Environment, and myself became involved with the project. We received a call and correspondence from Royce Brook, given our prior experience on the site in 2017, and the fact that we knew the site, and we had done some reporting and some investigation on the property. Once they became aware of the resolution and the sampling requirements, they were looking to hire an environmental consultant to comply with the resolution and the monitoring plan. As soon as they became aware of it, they passed along any information to us that they had. We conducted a site visit. We met with Royce Brook personnel to identify sample locations and to get a better sense of what the resolution what had to be completed in accordance with the resolution, and the sampling then began. And I believe that, again, that was in late 2019.
Okay. I'm going to show you what I've pre-marked as A6 as a proposed exhibit and ask you to identify it, please.
This is the proposed groundwater and surface water sampling report dated October 18th, 2023, prepared by Delta Environmental Services and signed by myself, Daniel Latanzi.
Okay. I can deliver an original copy to the chair. You want to pull that up, David?
This one?
Yeah.
Pull it up right a second. Does everyone have this?
My understanding this was provided to your office,
Yeah, this was provided previously, correct?
Yes, absolutely.
all right, and was
So you don't need it, though.
posted on Civic Clerk?
Yeah.
Okay, we're marking it as A6.
A6.
Okay.
A6.
Okay.
10/27, 23?
10/18/2023. 10/18. All right, you want to go through A6, please, for the board and the public?
Sure, this is another reiteration of a prior plan that was submitted by First Environment, but we, based on some discussions with township professionals and review of data, we submitted this sampling plan. As I said before, the 94 resolution included a monitoring plan to test groundwater and surface water to evaluate any potential effects from golf course operations. This plan serves to modify some of the sampling requirements and some of the protocols, and really to bring them more current. Again, the resolution was from 1994. We're now in 2023. The department certainly has updated their requirements from a technical basis and some of their guidance as well. Laboratory analytical parameters have changed, standards have changed, and we want to make sure that this monitoring plan is appropriate for current conditions at the site, as well as in terms of a regulatory framework. It details certain sample locations for monitoring wells and for surface water. It details the current septic system monitoring wells, which are currently under a DEP approval permit. It also details prior soil testing that was performed to evaluate for whether pesticides were impacting soil quality within the redevelopment area of the property, and it also includes a proposed reporting schedule and monitoring plan for continued testing.
All right, is this A6 proposed by the applicant to replace the existing groundwater and surface water sampling plan?
Yes.
Okay. All right, I'm going to show you what I've marked as A7. You want to identify that for the record, please?
Okay, this is a groundwater surface water results letter dated October 27th, 2023, also prepared by Delta Environmental Services and signed by myself.
And this document was also part of the record in this matter in terms of being posted on the Civic Clerk website. Is that correct?
That's correct.
Okay, you want to go through the A7 with the board and the public?
Sure. As part of the monitoring plan that I just described before, we, and also as part of the original resolution, there were monitoring phases and plans to be performed on a biennial basis, usually in June and October of each calendar year. Now, my sense is that sampling program came about because of, again, golf course operations, right? Typically a summer sport. There may be more applications of pesticides occurring during the summer months, so there's testing to be performed early on in the season, and then again when the typical golf season starts to slow down in the fall. This letter dated October 27, 2023 details the sampling that was performed by Delta in October of 2023. It included the collection of groundwater samples from 2 monitoring wells on the property, one labeled MW6, which is a shallow bedrock monitoring well installed on the eastern portion of the property. That monitoring well is installed to approximately 35 feet. And we also recently installed, and it details the installation of a deeper bedrock monitoring well to 123 feet. Given if our past meetings and some of our correspondence, there was some interest in Royce Brook evaluating deeper groundwater conditions, given that the original resolution required a well that was to be installed between 40 and 120 feet. Given some of our...
So Royce Brook responded to the board's request and some of the report's request that another well be dug?
Correct.
Okay, and that's...
There was a request, we spoke to township professionals about those specifications for the well, making sure that the well is installed in accordance with DEP requirements, and also to make sure that we're collecting appropriate data to show the water quality as it pertains to the golf course operations.
So that was in addition to the, what we've previously identified as monitoring well 6, is that correct?
Right, so this is, right, we essentially added a deeper well, MW6D, and this was the first sampling event for the new well. We had it installed in accordance with DEP requirements. We waited the 2-week waiting period before we collected the sample, and then those samples were submitted to a DEP certified lab for the analysis. And again, that all the analytical parameters and the testing requirements were included in our sampling plan dated October 18th. So we're really simply just trying to follow the plan that we're proposing, and this letter highlights some of those results for these groundwater and surface water samples that we collected.
Okay. I'm going to show you what I've marked as A8, and could you identify that for the record, please? We're going back in time a little bit on this one.
This is a site investigation summary report dated November 24th, 2020, prepared by First Environment, and it is also signed by me, Dan Latanzi.
And that was directed to Toll Brothers, was it
That is
not?
correct. It's directed to, this is work performed by Toll Brothers. This is essentially what we call a Phase 2 report or a site investigation report, where we're collecting samples on behalf of a party that's looking to purchase a property under due diligence. In this report, there was soil samples collected from the property. Approximately 50 samples were collected for laboratory analysis. And the testing was performed in 2017. But over time, while we had provided that data to Toll Brothers, we never had prepared a formal report up until November of 2020. So this November 24, 2020 report, again, summarizes the sample collection process, where it has a map showing where all the samples were collected. I believe we shared that in one of our past meetings. It includes all the analytical results for pesticides and for other potential parameters that could be associated with former and current golf operations. And it also included a summary of the results, which basically showed that the analytical results did not show anything in terms of pesticides that were above the DEP soil remediation standards.
Okay. And the final exhibit I have for you, I've marked as A9, and could you identify that for the record, please?
Sure, this is, again, a groundwater surface water results letter dated November 1st, 2023. This is an addendum report to Exhibit
A6.
A7.
A7?
Yeah, Exhibit A7. Essentially, this is the same report that was submitted on October 27th, just that unfortunately, due to some time constraints and laboratory turnaround times, we were not able to provide the pesticide results for certain samples that were collected. So we simply wanted to provide an addendum to make sure that the record was complete for the October sampling event, and these results are presented. So again, basically, this report dated November 1st and the other dated October 27th are complete and show a clear picture of the sampling event that was performed in October.
And what were the results of the October testing?
The October testing showed that there were no organophosphate pesticides detected in groundwater or surface water. There were detections of fecal coliform in surface water samples. There was a detection of fecal coliform in the shallow well MW6 above groundwater quality standards, but fecal coliform was also not detected in the deeper well that we installed, again, MW6D. There were other parameters that were...
That's the well that was recommended by the board's professionals and the board, is that correct?
That's correct. There were other compounds tested for as well, but again, those parameters were in compliance with DEP surface water quality standards or ecological screening criteria.
All right. Having submitted these reports and this information to the board and the public, did you arrive at any ultimate conclusions?
As I said before, the data further supports the fact that golf course operations have not impacted the environment on or adjacent to the property. The testing meets the original purpose of the resolution that was issued in 1994, which again is to protect the environment and human health and to determine if there was any impact as a result of golf course operations. Again, given the data that we've collected to date, which is at least 6 rounds of data, we have no evidence to suggest that the golf course has impacted the environmental quality.
Let's talk about the 6 rounds of data.
Sure.
How does that mesh into your opinion?
Well, I think, typically in DEP regulations or requirements, you're required to perform repeated testing to make sure that the data is valid and that it's usable and it's appropriate. And the department typically requires a certain number of samples be collected to confirm your findings. You simply just can't go out and collect one sample and call it a day and say that everything's copacetic based on one result. We need repeated results. We need repeated data collected over time to show what effect, if any, operations, whether it be a golf course or any other kind of type of operation, is affecting the environment. But given the results that we've collected, like I've said before, we've seen no environmental impact from the application of pesticides or anything else that is occurring on the Royce Brick Golf Course.
Are there any administrative code regulations that apply to that situation?
Yes, well, I said before, the department has copious amounts of guidance documents for LSRPs to review, and we need to be knowledgeable of them. One of them is the technical requirements for remediation, and another is the attainment guidance that the department has. And they outline in these guidance documents and in their technical requirements the number of sampling events that an LSRP or an environmental professional would need to perform to confirm that there would be no impact to an environmental medium such as surface water or groundwater or soil. So our testing, while we are preparing a separate plan that's outside of the DEP, right, we're not submitting this plan to the DEP, we are trying to perform that work in accordance with their requirements.
Okay. And the applicant is proposing a sunset provision on future testing?
That's correct.
And you want to explain that to the board, please?
Sure. In prior discussions and also in our monitoring plan, we are proposing to continue to collect data. Like I said before, we've started our monitoring plan in 2019, and we intend to continue to collect samples, repeated samples, for at least another 2 years. That will allow us to collect a total of 10 sets of data. We feel that that is appropriate, given that the department typically only requires 2 consecutive rounds. We feel that 10 rounds would be appropriate. This will apply to the existing well, MW6, and the new well, 6D. Now, 6D is new, and we realize that's a new well, and we, based on my discussions with Royce Brook, we're going to commit to continue sampling that well until we have 10 consecutive results to show that it's clean, and we'll also continue to collect samples from the surface water locations that run along the eastern property boundary.
Okay, to tie up some loose ends, did you have an opportunity to review a report that we received yesterday, a November 8th, 2023 report from Pannoni, and signed by Todd M. Hay, who's here tonight as the board engineer? Did you have an opportunity to review that?
Yes.
Okay, and do you have any comments with respect to that report?
Yes, I've had an opportunity to review Mr. Hayes' report, again dated November 8th, 2023. Based on my discussions with Royce Brook, we are going to provide a response and make sure that we provide Mr. Hay and his office, as well as the township, with any data that we've collected to date in terms of reports that I've discussed tonight to ensure that the record is complete. We'll make sure to provide any historic results and reports, any safety data sheets that the golf course may have in terms of their application of what they're applying at the site. We will also make sure to provide the monitoring well record for the new deep well, MW6D. When you install a monitoring well in New Jersey, that has to be approved by the department, and then they provide you with a record. Unfortunately, that record was not available prior to this meeting, but as soon as it becomes available and the department approves said record, we'll make sure to include that in our response to Mr. Hay.
Okay, starting on page 3, Mr. Hay makes certain recommendations. You want to go through those recommendations?
Sure.
And the applicant's position with respect to those recommendations?
Sure. Under recommendations, Mr. Hay suggests or recommends that testing will need to be performed until 10 non-exceedance results for 5 years is acquired. Like I said before, we already are at about 6 data sets total for the existing well MW6 and the surface water samples we've collected. Of course, we've only collected 1 result from MW6D, and those results, again, showed no impact above DEP standards, including fecal coliform. And we're going to continue to do that testing. So we're going to have a little bit of an odd schedule. We'll have the testing that was being performed for 3 years will continue for 2 more, and then we're going to have to continue beyond that for the deeper well to make sure that we get the 10 total sets. So it's a little bit of a change from our original monitoring plan where we were going to go only to 2025. This testing, given the new well, will extend beyond that.
Okay. How about recommendation number 2?
Recommendation number 2 refers to a suggestion that the 19 homes in the vicinity of the golf course be tested, given some of the results that were collected by First Environment and Delta. As I said before, the only compound that has shown any concentration above a DEP standard is fecal coliform in monitoring well MW6. If you recall, this monitoring well is fairly shallow. It's located in the shallow bedrock. There is no shallow groundwater at the property. It's just all in rock. And we feel that given this result and the fact that fecal coliform was not detected in the deeper well, which is where you would expect a potable well to be installed to that depth, we're not really in agreement with moving forward with that type of testing. This is based on the fact that fecal coliform was also detected in at least one home prior to the golf course operations. That was documented in subsequent reports prepared by Equal Sciences in 1998 that at least one home had a detection of fecal coliform. We've reviewed the township's website that suggested that testing done throughout Hillsborough, specifically in this grid, in this area of the town, approximately 3% of the homes tested identified fecal coliform in their well. We feel that fecal coliform is not representative of golf course operations. Of course, fecal coliform is really attributed to waste products. We feel that it's attributed to animal waste products. And if anyone's ever been to a golf course, you could attest that. And there's certainly different types of birds or waterfowl that are near the river as well that could be contributing to elevated levels of fecal coliform and MW6. So just to reiterate, Royce Brook is not inclined to perform additional testing for the 19 homes.
And is that based on your professional opinion?
That is.
And recommendation number 3 regarding the septic system that appears on page 3. What are your comments with respect to that?
The testing, Mr. Hayes said the testing should continue on a biennial cycle until the system is removed. If no groundwater is detected, no sampling will be conducted. In our monitoring reports, we have detailed consistently that groundwater in these wells is not present, therefore testing cannot be completed. This information is also presented to the department because since the septic systems are under a permit, we have to keep the department informed of our investigation activities as well. So we agree with Mr. Hay that we will continue to test. We will continue to see if groundwater is present, and if it is, we will test. If not, we will make sure that it's reported to the appropriate authorities.
Okay, recommendation number 4 on page 4 regarding surface water. Do you have any comments with respect to that recommendation?
No, we have no comments. We will continue to do the testing as outlined in the recommendations. 5 years of biannual data will be collected, so that will be 2024 and 2025. We'll make sure in a technical response to Mr. Hayes' office, we will provide some information regarding sampling requirements, laboratory testing, and some of the limitations that DEP labs have in achieving the surface water quality standards. We'll make sure that we'll provide the method detection limits that the labs use, and we'll also make sure to provide complete laboratory reports so that his office can review those results in full.
Okay. All right. Yesterday, we also received a memorandum from Michael Carr. He's here. He's the Director of Environmental Programs. And it was referencing the proposed groundwater and surface water sampling plan for Royce Brook Golf. Did you have an opportunity to review that document?
I did.
Okay, you want to issue any comments with respect to that document?
This document that Mr. Carr prepared and provided somewhat mirrors Mr. Hayes' report regarding 10 data sets over 5 years showing no exceedances to applicable standards, which we agree. We agree that the wells that are near the septic system will be abandoned by a licensed well driller once the septic systems are removed, and we'll make sure to document decommissioning to the township. We'll make sure to gain those reports from the department so that they're on your file. What else we have here? I just discussed the fecal coliform result in monitoring well 6 and why we feel that's attributed more to ambient conditions or the presence of animal life on near the golf course. Of course, when we continue to sample these wells, we'll try to reduce levels through sampling. If we are able to reduce turbidity in the wells, we may be able to get some more favorable results in terms of true concentration. We'll make sure to have that field observations noted in future reports, which we have not been doing yet, but we will continue to do so in the future. And then again, too, I think actually in one of my more recent letter reports, we'll always continue to copy and send in our reports to your office as well as to Mr. Hayes to make sure that the township has a complete record of all of our sampling.
Okay, and just to tie up some loose ends, and I know you testified partially at our last hearing regarding the Environmental Commission's July 18th, 2023 report. But again, the hearing took place 2 days later, so we
Right.
didn't really complete the presentation. Have you had an opportunity to re-review the July 18th Environmental Commission report?
Yes, I have.
Okay, and are you going to provide any additional comments with respect to the same?
Yes, I just want to get to their comments real quick here, just to make sure. One of the questions was, has any pesticide sampling been conducted or requested at the site? And in the record and as posted on Civic Center, First Environment previously completed soil testing at the property in 2017 and included approximately 50 samples collected over various portions of the property. Samples were collected biased to where we would expect to find pesticides collecting, for instance, along greens, fairways, tee boxes, things where, of course, you don't want weeds growing. Those samples were collected and submitted to a DEP certified laboratory for pesticide analysis. And of course, this testing was also performed in anticipation of the change of use of the property. As outlined in the site investigation report dated November 2020, all pesticide concentrations were either not detected or below New Jersey's residential soil remediation standards. So in response to that question, that information has been presented in the November 2020 report. It's also summarized in our October 27th, 2023, October 18th, 2023 proposed groundwater and surface water sampling report as well. Let's see. Applicants should provide results of the recent sampling of the 4 Nigyptes wells, which are, of course, associated with the septic system. I just went over that we'll continue to monitor those wells, and if sampled, we'll provide those results to the township, or we'll also continue to show that the wells are simply dry. We'll make sure that that's documented. I think that's it.
And again, is it your opinion that further testing of the off-site wells are not necessary?
Further, any additional testing of the off-site potable wells, based on the evidence that we've collected to date, in my professional opinion, is not required at this time, given the copious amounts of data that shows that there's no impact to the environment as a result of the golf course operations.
As a result of your participation in this application and before this application was commenced as an LSRP, can you give the board and the public your ultimate opinion with respect to what the applicant is proposing?
The applicant is simply proposing to modify the prior sampling plan that the 94 resolution contemplated, which was, we understand that there's operations ongoing at the golf course. We want to make sure that the environment is being protected through said sampling. Again, as I said before, there's been certain regulations that have been updated since 1994. We wanted to bring it current. We wanted to make sure that the monitoring was done appropriate in accordance with DEP requirements. And we also wanted to make sure that the proper number of data sets are collected to confirm and ultimately continue to show that there's no impact to the environment as a result of the golf course.
Okay, I have no further questions.
Mr. Hayes, you have rejected a couple of times, so.
Yep, no, I appreciate that. I had a chance to listen to the testimony, I had a chance, obviously, through our letter to evaluate the sampling plan as well as some of the results that were provided by Delta. I also have been discussing it with Mr. Carr concerning some of the issues that we brought up at the last hearing to get a better understanding of what is actually going on there. The well that was drilled gave us a little bit more comfort as to knowing what's there, what's not there. The fecal coliform obviously is an issue, but if it can be sampled over the next 5 years, we can, and both wells, we can get some assurances that those issues will hopefully be put to bed. Obviously, if there's issues beyond that, that plan would be retuned. That report would go to Mr. Carr. He would have to review that, but to be honest with you, I have more of a comfort level now knowing that we don't have any issues with pesticides. We don't have any issues that are in detriment to the health, public safety, welfare. So that was reassuring. And some of the other items that the LSRP, applicant LSRP mentioned, we're in total agreement with. The 19 homes, I mean, because of the deep well, we don't think it's necessary. Mr. Carr and I discussed this at length, that we don't think that the testing is going to be necessary for the 19 homes, especially with the fact that they're going to extend out this monitoring with this new well that was drilled in October for the next 5 years, through 2028. So we'll be able to monitor that and know what the results are, because it's going to be a dedicated monitoring well. They have to submit a plan to DEP, it's got to be monitored, the results have to be shared with the township. So I really don't have any other comments other than I would ask the board to take the conditions that are provided in my letter and to put them into the resolution for this amendment. I thought that would probably be appropriate. We'll work with them on some of the analyticals that were mentioned by the applicant's LSRP to make sure that they've been clarified. and that they're understood, so that when we do a response letter, the board knows what we've looked at and what we're considering, and that it's not going to be a detriment to the public health, safety, and welfare. And that's my testimony.
Okay, thank you. Carr, anything to add?
I think Mr. Hayes.
Microphone.
Turn the mic on. Green light, there you go.
Mr. Hayes and I have been talking about this at length and feel comfortable and confident in his assessment as well.
Thank you. Ms. Coyce, anything?
I have nothing to add. Thank you.
Okay. Board members?
I have one query, and we've talked about modifying the tests to, I guess your words were, a more current standard. So what are we changing what we're testing for? Are we changing the numbers that we're looking for? So I didn't see anything reference to what this modification is. What are we looking to do as far as in the testing procedures? I don't know if you can answer or Mr. Hay. I mean,
Sure. So originally, in the 94 resolution and the monitoring plan, there was a well that had to be installed. And that was recommended by Eco Sciences, who was the consultant on behalf of the township. And they wanted, previously we talked about this a little bit, but in there, they wanted a well that was going to be, that would mirror the neighboring wells,
Right.
a potable well.
Okay.
They wanted it from 40 feet to 120 feet, open borehole, so you can collect water in it. And typically, that's what you do with a well, right? You have a well with multiple fractures, so you could pump from it, and you could, feed your home with water. Over time, DEP's regulations have changed, and they have, there's a well construction requirement. There's an actual document that you have to file, and for a monitoring well, you cannot exceed 25 feet of that open space, right? So possibly in 94, that would have been allowed. Nowadays, that doesn't really match a monitoring well. So that's one update. There's been updates to analytical parameters. The EPA and the DEP put out new methods that typically are required. We want to make sure that those were current. So that was an update as well. Some sampling procedures have been updated too. When you collect these samples, there's different ways to do it. The procedures that the DEP prescribe, you have to follow. Those are simply some of the modifications that we are looking for.
So those will be indicated in the new resolution as to what exactly and how we're testing and what well we're doing, I'm assuming?
It would
Right.
actually, it's already been articulated in the sampling plan.
Okay.
I mean, that's the plan that we originally reviewed, just to make sure that there was an understanding that when you put up a new sampling plan, we have to review that first before they go ahead and go further with sampling for the next 5 years, including the next 2 years with the surface water. So we've done that, we made sure that that's been looked at, and yet the parameters have changed. It's changed significantly over the last 30 years. It's gotten actually more, I want to say, adverse to the applicant in terms of what exceeds.
They have to look at, so, sorry about that. But,
Yeah.
yeah, I want to make sure that the public understands that, the plan that was passed in 1994 is completely different than the one now. This one's going to test just about everything, and we'll get a better understanding. Mr. Carr will get the results and be able to analyze those, and then you obviously disseminate that to the public. So, but at this time, with the sampling that we've seen, we don't see it as a detriment to the public health, safety, and welfare.
Okay, and I got one other follow-up, just as how the procedure is done. So you go there, chain of custody, you take the water out, you put it in a seal, you seal it, Royce Brook on it, it goes into some box.
Yeah.
And then, so just explain us the chain of custody of when you do a sample and how it gets done.
Right, so you're provided with laboratory-supplied glassware. You go to the lab, that's DEP certified, they give you the glassware with sometimes they have preservatives in them, depending on the type of analysis. You send someone out, they will purge water from the well, they'll use a baler to drop the baler down to collect the water, they'll transfer the groundwater into said jar, similar to surface water. We have basically what's a glorified bucket baler where you stick the bucket into the surface water from the shoreline, you use that to pour it into the glassware. That glassware then, that has the water filled in it, goes into a cooler, it has to stay on ice, and be delivered to the laboratory. The laboratory needs to make sure that the cooler stays a certain temperature to preserve said samples, because of course, some sample parameters, if things get heated up, they could ruin the sample quality. With that cooler comes what you just said, the chain of custody is filled out by the sampler, it's signed off by them, and it's also signed off by the laboratory. That chain of custody eventually makes its way into the data table and the data report that the laboratory provides, and it's an actual record of the sampling that occurred. It shows the type of sample you collected, the lab analysis, the date, the time, the parameters, who sampled, gives a lot of different information, and we treat that as almost as a legal document because it goes into a record eventually.
And the people who do the sampling at the site are employees of your company or
Yes.
independent?
Yes.
Your company.
They have to be trained in proper sample collection. Like I said before, the DEP has certain sampling procedures. They actually call it the Field Sampling Procedures Manual. You have to be well-versed in how to properly collect the sample. The DEP prescribes certain methods that you have to perform in the field, readings that you have to collect, things that you need to do to make sure that the sample is of sufficient quality before it's sent to the laboratory and tested.
And last question, is there like photo evidence as you go along, you take a picture and then that's just to prove it as you go on, or just a sparse code that you scan, or how is it?
That's a good question. I mean, if we see something on site that's out of the ordinary, we'll take photo documents. But when you're collecting a groundwater sample, it's really, you're just looking at a well. If, say, you're collecting surface water and I know this river doesn't run dry, but show up in the river and the waterway is gone, or it's dry because it's in a dry season, sure, photo documentation. But we also record everything in a legal book that's documented. We know everything that we've done on site, went to the moment we arrived, to the weather, the time, and in 15-minute increments, we describe what we did during that day. So that book also can become part of the record if requested down the line. That's a requirement that LSRPs have to document their field sampling procedures and to make sure that there's some sort of record. So not much, you can take photos, but more so it's writing down the procedures throughout the day. Those notes then get passed on to the LSRP, if this was an LSRP case, or simply if I'm managing this, I review those records to make sure that the work was done appropriately, and that way we could use those notes to prepare the reports that I've provided to the township.
Thank you.
You got it.
All right, just to follow up with the mayor, so with these procedures that the mayor had indicated to you, you as the LSRP would be supervising and overseeing the employees?
Correct. Yes.
Any other comments from the dais?
Yeah, I had a question. So when something goes out of range, looking at some of these tables, there's testing that was done and things that come up in bold and they're out of range. So continued testing, something goes awry and there's something out of whack. What happens? And when it does happen, how do we handle that? What are the penalties? So I guess the question is, for all of you professionals up there, walk me through when something goes wrong.
Well, it depends on the data you're working with, and that's why we have this robust monitoring plan to continue to test and show repeated data. You may test something, and something pops up, and you're questioning, well, is this a one-time thing? Is it just because of the conditions that were encountered during that one specific date at that specific time, or is this something that is actually consistent? And that's why you continue to do repeated data over time to show a trend, to show if it's actually something that's verified. So to answer your question, like if you had, we don't have any exceedances as it relates to the groundwater or to the surface water, to the soil. Of course, fecal coliform was detected above a groundwater quality standard, but we're not contending that was from the golf course itself, but more from wildlife. In a typical setting, if you had an exceedance, you would have to address it again through continued monitoring and reporting. The department prescribes different ways to address it. There's really no cleanup for certain compounds that we run into here, but there are different ways to handle it from a regulatory basis if needed. I'm kind of grasping here because I'm not seeing an example here where what we would do, or a hypothetical of what happened if something were to be exceeded. But again, we'd make sure it was verified and true before we would react or report anything else. Hope that helps.
Thank you. I was just referring to the soil analytical results
Right.
I see for pesticides, and, there are various things that, again, they come out, they're not NDs, which I assume is not detected, but other
Right.
things are detected, and they're
Correct.
out of the range, I guess, if it's in bold, it says exceeds NJDEP standards, so that
Oh.
was really my question.
Yeah, so that's a little, see, it says bold shaded exceeds DEP standards, so the shading's the key. Sometimes what we do is we bold those results because in a sea of ND, sometimes you're looking through this and it's hard to identify if there's any actual detections of a pesticide. So, for instance, there was a few detections, I'm hearing,
So, okay, bold is just it's detected. If it's shaded, then
Is that
it's
me?
an exceedance. Okay.
right, sorry, yeah, I see how that might be a little misleading there.
So back to my original question, let's say it is in bold and it does exceed, what's the, I'll ask my professionals, what happens at that point?
Yeah, I don't know. Maybe we should back up. Thank you. It is. Well, I see a green light. Hello. The resolution contemplated if there was an exceedance, that there would be additional testing. Like the resolution said some form of investigation or remediation would occur, and that could, it really depends on the media you're testing. So you talked about the soil. If we had a soil exceedance, the DEP prescribes certain methods for a party to remediate soil. Simply, it could be excavation. It could be, the department allows soil blending. There's different remedial strategies to address something that's above a standard. So that's across any media that you're testing. So if something were to occur, that's something we would evaluate and have to discuss internally to get to an endpoint where it's returned to protective or below standard.
I'm assuming there would be at least an OOS investigation at the lab just to make sure it wasn't lab error.
But I think it's tough because they're DEP certified and they have chemists on staff and you could review the lab reports with them. They're pretty, they're pretty spot on. But again, that's why you repeat. Was that an error? Was it really something that occurred in sampling in lab analysis? And that's why you just have to try to confirm what's going on. But if you do see something out of the ordinary, you could always ask the chemists, and they will review in detail the report. To be honest, I'm an LSRP, but I rely on other professionals for my license. I am not a chemist. I do not fully understand how they get to these levels, and they analyze and they prepare their reports. So I rely on people who have, other skills to help me and support my professional opinion.
Sorry? No, you look like you had something to add.
I follow one other thing on that before you answer. So is there a time when it triggers an extension of the time of testing if the numbers keep showing up, maybe for 2 consecutive reports or anything like that? That it go past the 5 years or whatever it is?
It's not exceedances. If you don't have 10 consecutive non-exceedances.
You got to have 10 consecutive for it to consider.
You gotta keep
So
testing.
1 or 2 or whatever, it doesn't matter, but it's got to be 10 consecutive.
Correct.
Okay, that's what I'm
Correct,
asking.
yeah. There's some projects I know that we have, at least in my company, that have exceeded, we say 5 years and then it ends up being 10 years. That's what happens, unfortunately.
Right.
But, to kind of cover the LSRP, some of the analytics that they get, they do rely on those analytics. Some of those can be easily explained. When they exceed a level that is beyond, then yeah, they're required to report it, and then they're required also to come up with a mitigation plan.
Right.
In this case, the exceedances are not that much beyond. We did find some anomalies in some of the data. We've asked them to take a look at that, reevaluate it, and explain the anomalies in a report back to us as part of a condition that I'm asking the board, if they're to approve the application, the amendment tonight, to consider.
Any additional comments? So with that, may I have a motion to open the public, please?
So moved.
All in favor?
Aye.
All right, okay, if there's anyone in public that would like to ask this or question this witness on his testimony, please come up to the mic, state your name and address for the record, please.
I didn't bring water. Water. That's okay. Don't worry about it. Don't worry about it. Just next time for next time.
Tom O'Donnell, 33 Ann Street. And first off, believe it or not, I looked at 443 pages that were in the packet. So hats off for burying the data in a lot of data, which was interesting. Couple of comments. There's so many places I want to go with this, but the first comment I want to make is we'll just start at the end of that last conversation. There was a whole bunch of comments around not exceedance. And in the last meeting, the sentiment that was shared was any trace of these chemicals is considered a failure according to the original monitoring plan. Does anybody want to address that? Choice of language. It seems like the language has shifted this meeting.
Would you like me to address that, Mr. Chairman?
Sure.
I mean, we've reviewed and I think Mr. Carr would agree with me that if there is any concerns with respect to pesticides, insecticides, any type of chemicals, the 100-foot well was to show that there was not any issues that the public should worry about with respect to those issues. Listen, the fecal coliform that came up, the exceedance is not excessive in terms of an explanation that's needed beyond what the applicant's LSRP already provided. I'm accepting that. My LSRP has actually looked at this and he's accepting it as well. Mr. Carr is accepting it. So we're asking that the monitoring continue with the existing well for the additional 2 years, and that for the next 5 years, going into 2028, that the new 100-foot drilled well, which, by the way, I want to make sure I mention to the public, the applicant really didn't want to do, but I told them they got to do it. So, or I'm not going to accept it. They did it, and the only thing they found was the fecal coliform. Well, actually, they found nothing in the well, and because they found nothing in the well of nothing, and it doesn't exceed DEP limits, we can't do anything beyond that, with this applicant. If it exceeds it, it would have come up in the analyticals, we would have looked at it, and we would have flagged it. Mr. Carr would have flagged it as well, and we would have then proceeded to come up with, and I want to say recommend a mitigation plan. That's not required in this instance for that new well, but we are requesting, and not requesting, we're requiring that they test this new well for the next 5 years. And if there's anomalies, Mr. Carr will evaluate that. The township has asked me to be involved as well if there is some analyticals that we need to decipher and help Mr. Carr understand, and we're going to do that internally because this applicant has to notify the township with the results over the next 5 years with that new well. So I just want to make sure I make it clear that this well, there's a lot of, it goes back to what the 1994 sampling plan required. The applicant didn't feel that they needed to do that based on, their prior testimony. We told them we needed to see it to make sure we understood it and make sure there wasn't another hidden problem. There are no hidden problems. There's no problems. There's no exceedances of any level within that new well.
Okay, well, we're on the subject of the well. So now the well is 120 feet deep, correct? Is that my understanding?
123.
123, which is great. I mean, that is more in line with the essence and the sentiment of the original monitoring plan, which we appreciate. I'm not sure, but I sense that its construction is different than the construction of, say, my drinking well in my house. Is that true?
Correct.
Can you elaborate on that?
Sure. I believe I spoke to the mayor before about this, but the original resolution wanted to have a monitor well that mirrored a potable well that's in next door, right?
Sure.
That type of well, for monitoring purposes, is not required. Not required, is not appropriate in accordance with the DEP's regulations. So
Okay.
for a monitoring well, your potable well probably has an open borehole that crosses multiple fractures so that you can pump as much water as possible within reason into your residence, right?
Yep.
And that's why
I have
they.
a sleeve that's about 10, 20 feet deep.
Right, so they have that has some will be 40 to 120, some may be 50 to 150, different depths depending on the fractures that you're hitting as you're going down. We couldn't comply with the 94 resolution because the department wouldn't require us. We go to submit a permit for a monitoring well. We say we want to put a well into 120 and screen it, or have an open borehole from 40 to 120. DEP said, sorry, licensed driller, we can't allow you to drill that well. That's not
Okay, so
appropriate.
what does the construction look like? How
So the-
far is it lined?
So the well is from, let me look at it real quick. I'll give you the exact.
And you're hitting exactly, you're highlighting my personal concerns because my well is going across a completely different fracture structure than your test well, correct?
So the new well is from 97 to 123 feet. That's where it's screened from. That's where the water is entering. We also have a well at the top of the formation that's down to 35 feet. So that well is from 15 to 35 feet is screened. So we're intercepting the superficial water that's coming into the bedrock, right? So we have the ground surface, we have soil that has no water in it, and then we have bedrock, a confining layer, and then there's water in the shallow zone, and there's fractures as you go down. So we're basically canvassing the shallow, where we anticipated before, as Mr. Hay said, my prior testimony was saying, that's where you're going to find anything. If there's any pesticides on this property, if there's any contaminants, that's where you're going to see it. And that's also why you're seeing higher fecal coliform, because you're closer to the surface. You're not seeing it deeper because it cannot migrate that far. And the other thing about these compounds is that they don't readily leach into groundwater or surface water. They actually are immobile. They adhere to soil. And then we did the soil testing. There's nothing in soil. So a lot of that information just leads us and ultimately suggests that the golf course is not impacting the environment. But I can't really speak directly to where the fractures are at your well and where ours is. It's just we tried to match and try to, within the regulations, to match what the 94 resolution had intended.
Do you know at what depth you hit the water table?
It depends. Each well, even though they're fairly close to each other, the fractures here are horizontally bedded, but they do dip. So it does undulate, but it's typically around, the first water-bearing fracture was encountered around 25 feet below surface.
Okay.
But then there's multiple fractures as you go down that you keep
But that
hitting.
25-foot fracture is not going to be where a potable well. You're not going to draw from that for a house.
I don't know, actually. I mean, if you could still, someone could install a potable well that shallow and just continue it deeper to.
All right, so my
water.
point is,
Right.
I appreciate that it's deeper, but it's not representative of what we have for our wells, for our drinking water. I get it that it's possibly regulated by the government, but also your professional opinion is that you were not going to be able to put a deep well on that property, was it not?
Originally, it was. Originally, I didn't feel that it was required. I think because of comments received by the township and from the public, we felt that there was a need to show that not only was there no impact in the shallower zone, there's not going to be any impact in the deeper zone given our knowledge of the site and the data that we've collected. So that's what Royce Brook committed to doing it, and they're going to continue to monitor it to make sure that holds up.
But I have a pretty good memory, and your testimony wasn't that you recommended it. You said that you could not do it. That was your testimony. Do you recall that?
I legally could not put a well in that mirrored a potable well.
That you could not put a 120-foot well on the property?
I couldn't put a well in that was open borehole from 40 to 120. Like I couldn't put a monitoring well in that
I don't
it has the
remember.
same construction as a
All right.
potable well. Right. So I could put what we did.
You might have given those details and I didn't pay attention to them, but I
That's all
heard
right.
you say that you couldn't do a deep well, and my point is that today we do have the deep well, that at least is closer to what we're doing with our homes. I've gotten very good at picking up on language
There you go.
in testimony. And you had one interesting comment, well, a couple of them, but one of them I'm going to, hate to pick on you a little bit here, but
That's okay. That's
the
okay.
use of the words abundance of data.
Correct.
You have how many tests done on our stormwater, and how many tests done on this deep well?
We have, I don't know about stormwater. I don't know what you mean about storm. I don't think we've collected any stormwater.
You started
data.
testing, how many test results do you have since you started testing, 3 years ago?
We have at least 6 rounds of data
Okay.
collected.
So
And
how
I'll-
many,
Okay, go ahead, keep going. Sorry, guys.
that's the answer I'm looking for.
Sure.
How many tests should have been done if this 1994 resolution was enacted and enforced from day one, when the golf course was built in 96?
How many data should have been collected?
Mm-hmm.
I couldn't give you the total number. I mean,
Would you say close to 200,
no, I don't think,
combining groundwater and
like, number of
wells?
samples?
Yep.
I'm not that quick on the math, but,
Okay. Well, I am, and it's close to
okay.
200.
okay.
To me, that would be an abundance of data. One test is not an abundance of data,
Okay.
okay? So that's a very interesting use of the language. The
Let me,
other- Go
can
ahead.
I comment back on you on
Yeah,
that?
please.
So, from a regulation standpoint, and I'm an LSRP, right? And, you have data. And we talked about before about repeating the data. If you sample something and you get a result and it's below standard, say you sample MW6D the first time, it's non-detect, you sampled again, that's well enough for the department to show that there's no impact to the environment. In fact, if you sample a point one time, the department can accept that in some instances, such as this deep well. We're, again, continuing to present data. We're going to continue to collect it. We realize, again, there was a data gap that was really not at a fault to Roycebrook. Once they found out about the resolution, they got right on the sampling and they started performing it. So,
But your deep well took 3 years to be built.
right.
That's not jumping right on it in my book. So, thank you for the clarification. And we'll go now to the next use of language. You are an LSRP, which is a remediation person, correct?
Correct.
Was the 1994 document a remediation plan?
Not remediation plan, but there was a monitoring plan
It was
with
a
it.
monitoring plan. Did it have a end date?
Not to my knowledge.
So it was in perpetuity, based on the way it was written?
Not-
Implied?
No, not, there actually didn't apply that it was in perpetuity or not. There was actually no documentation as to what the testing schedule would be, and that's why we set to modify it, given the updated regulations that the department has in 2023.
For a remediation plan?
So remediation. Okay,
What is the standard for a monitoring plan?
Remediation is a broad term, though, used in New Jersey. They can't say licensed site, investigation, assessment, remediation, professional, right? Remediation involves everything from your initial assessment, which could be even document review and site inspection, through initial sample collection, which is investigation, which really this is what this is. This is more investigation and monitoring, all the way up through an active mitigation plan, like Mr. Hay said before. Mitigation being, you might have something, how are you going to get it back to below standard or address it so that the public is protected? So use remediation somewhat broadly here in terms of our work.
Okay, give you latitude on remediation, I got it. Question, how long assuming this project is going to go through, how long will construction be going on?
I'm not aware of that. I'm not involved with the construction.
Did you consider that in putting your cap of 3 years from now?
No.
Is it possible that the soil disturbance, I get it, that these things are sticky, they stay in the ground, but is it possible that as these foundations and as this land is being disturbed, is it possible that you're going to disturb something sitting today in the topsoil and it's going to potentially make its way down into the drinking water?
No, again, that data, there's no data to suggest that pesticides are located in the soil, and that if the golf course has operated for such a long time and then sampling was performed in 2017, they're not going to just appear. There was sufficient time in between the start of the operations and the sampling that was performed. And again, we said too, pesticides tend to bind to soil. They're not going to readily leach into groundwater. They're technically what's called immobile contaminants or chemicals, right, by the department. They don't readily leach into groundwater. Usually, a lot of pesticides don't typically have groundwater quality standards because the department recognizes that they're typically not found in groundwater.
So your professional opinion is that the construction has no chances of having these potential chemicals that are sticking right now to the soil. There's no chance that they are going to, be disturbed and cause it to leach down through a very fractured ground, by the way, because we've all done work on our properties. There's a lot of shale, there's a lot of fractures in that ground. And so your professional opinion is there's no chance that the construction going, I don't know, at least 8-10 feet down to do these basements across this large amount of land, that it's not going to disturb anything that's going to be a concern that would make sense to continue monitoring?
There's no evidence to suggest that there's any impact to the environment now, and then nor will it be during construction. There's just no evidence that that would occur, given the data that we have currently. Plus, if they're doing foundations and they're digging out soil, that soil is going to have to be removed. So anything that you think may be there, which you're contending that is there, is going to be removed from the property, thereby almost assisting any potential soil impacts.
I see Mr. Hayes leaning forward. Do you want to comment on this?
Mr. Chairman, I just want to make sure
I just want to make sure I elaborate that, this application is about amendment for Royce Brook plan. Anything with respect to construction or what have you, as you know, we've gone through many applications with construction and massive earth moving within the township of Hillsborough. I can tell you that typically what happens is that an LSRP comes on site. If they find out that there's a problem with the soil, I want to make sure we characterize two things. There's soil and there's groundwater. Soil is one thing. If you have to look at soil, you test for any type of exceedances in the soil, and then an LSRP puts together a closure plan to either remove the soil, cap it, or what have you. We've gone down that road before. Groundwater is a totally different situation. Groundwater, if they go and do additional testing on site when they're doing construction, they don't find anything, they don't find anything. If they do find something, they either go ahead and monitor it or they go ahead and they treat it. There's no other things. Again, I want to make sure I reiterate to the board and to the public that there's been no exceedances, in terms of any type of exceedances with respect to pesticides, insecticides, or any other type of chemicals in the groundwater medium. There has been none, and we don't see any. And whoever is going to, if they come to this board with an application, they will probably have to reiterate the same thing. But we would like to make sure we mention that, that's something that Mr. Carr, myself, Mr. Coyce would vet prior to and let the board know that there will be a plan to look at soil, and if soil has to be properly disposed of, it will be. So I don't want the board to consider speculation. I don't think that's appropriate because I don't know what's in the soil. And you could go into certain hot spots and find out that there's exceedances, and then you have to go ahead and put together a proper closure plan to send it to the proper disposal site. So it's pure speculation. It's not, I would say, please do not consider that, because this is not about this. This is about an old plan being amended. I just want to make sure I put it on the record.
Thank you.
So the public's position, the neighboring community, Claremont's position is we've been neglected for 30 years, and we don't see a reason why this should be terminated after 3 to 5 years while we're concerned during, maybe it's ill-founded. I'm speaking for a community. I've got neighbors coming up to me raising concern.
What authority do you have to speak for your community?
I'm president of Claremont Community LLC.
But what authority do you have? Do you have an attorney with you?
I don't have an attorney.
What authority do you have?
I have there are other people here from the community that speak.
Okay. Talk. You're speaking, I want to make it clear that you're speaking on behalf of yourself.
All right.
Okay.
Fair enough. You're not a formal objector or representing any formal association or entity.
No, I
You're
don't, we
speaking
don't,
on your
we haven't
behalf.
hired an attorney yet to do that, so no, I'm not that person.
Okay.
So the question I have for them too is about the testing of the groundwater. Bucket method testing. Was that performed by yourself? Were you around for that testing?
No.
Are you familiar with the land that they tested?
The land,
The
meaning
wetlands
like-
between
meaning
the golf course and my
surface water
property
samples?
specifically, yes.
The surface water? Yeah, I mean, I'm familiar with that area, yes.
Okay. And would you say that there is normally standing water in that wetlands area?
Yeah, there could be, that could change. It depends on the season and, if there's been a rainfall event. I mean, we try to sample from each spot consistently, depending on, the location. We try to keep it consistent in terms of its general area.
Okay, well, I read the report on the testing, and I was very confused, and I'm very familiar with the land. It said that it was taken from the stream that flows into Claremont. That stream is on an easement on my property, and that stream bed literally terminates about 10 feet shy of my property and just turns into dry ground unless it has rained, and then it turns into water. And your testing was done on October 20 or 22nd, 2023, and I looked at the weather forecast, and it had not rained for a good week or so. So my question is, how could you use the bucket method in an area that is normally dry?
I mean, you said it's normally dry, but, our staff is on site. We're collecting water, whether it could be standing, it could be flowing. Water was available from, are you talking about surface water sample 1 here, sir? This is right, this is the one down here?
Yes,
Right.
there.
Correct. So, but we're collecting it on, it's near the boundary, but it is still on Royce Brook property.
I
So-
know. I know, it's in the woods.
Right.
And those woods is normally a dry forest floor. It only has water in it after a rainfall, and there was no rainfall when this test was taken.
Okay.
So that just, to your point, taking a picture proving that there was water there, Mayor, I just read the report pretty closely, and I was like, there's not really water back there, unless it's after a rainfall. So if there's a way to clarify that where exactly, I could be wrong, there could be a puddle of something back there that I'm not familiar with, but, I guess that would meet the requirement if they found like a puddle of standing water back there. All right, one of the biggest things is that we've got one test from one deep well. We would like to see more testing. I would like to see more testing. I think you'll hear the same from my neighbors. And what about the toluene and the Egyptes and stuff, the results of those testing on the septic system? And, there seems to be from time to time toluene. And to Mr. Peason, your comment, I read those, there was a lot of stuff in black, and I just summarized it as being lead, nitrates, fecal coliform going up to 460 parts per million. Mr. Hayes, I'm sure you're tuned into that piece, and that's something that's concerning. But there just seems to be some chemicals, maybe they weren't above DEP standards, but they were present, and that's why I'm tuning in or focusing on the use of language, whereas before it was like, if it's there, it's considered a failure. That point was very clearly made in the last meeting, and now we're going back to DEP standards.
Is there a question?
So, yeah, the question is, what about the toluene violations from time to time
Right.
in the septic system?
We've talked about that before. That sample was misleading based on where it was collected. The septic system and those wells are regulated by the DEP. There is a case manager. The case manager is provided with updates. We are in compliance with the DEP requirements in the permit. That septic system is going to be decommissioned upon redevelopment. And Frank, I'm sorry, when was the date for the sewer connection. I can't remember. Was it
Anticipated
anticipated? You know when that?
2025, I think.
Yeah, anticipated to be 2025 that the facility, will be connected to public sewer. So, when you're talking about detections versus exceedances, sometimes permits, like the permit for the sewer, for the septic system, may say you have a detection here, and it's not that it's a violation or that it's anything bad. It just has to be noted and discussed with the DEP to make sure that they're aware of it, and then make sure that the septic system's functioning properly. But there was no additional investigation performed on that, and we're, like I said before, Royce Brook is in compliance with the permit requirements.
Is the septic system potential source of the coliform?
It's not a potential source of coliform in MW6.
And going back to the years that were not tested, have you had?
Excuse me, which is the deeper well, correct?
It's the well, it's in the bedrock. It is
It's a 35-foot well.
Right, it's the shallower bedrock well.
And going back to your point about no violations, did you, Mr. Carr, is there on record about all the fish kills in Claremont?
I don't believe there's any record of it.
Okay, so we've had fish kills in our neighborhood, and we had conversations at the time with Mr. Belnay about that, and he said it was probably from nitrates. The comment was it could be either the golf course or it potentially could be our failing septic systems. So we took a
Mr.
look.
Chairman, that
I know,
doesn't sound like a
it's-
question, it sounds like testimony.
Testimony, I
Oh,
agree.
okay, fine.
Sorry.
So are you aware of the fish kills in Claremont community?
No.
Could a fish kill be caused by a nitrate getting into our water that wasn't being monitored during the time it wasn't being monitored?
I'm sorry, I'm not an expert on fish kill or aquatic life. I'm a remediation professional. Certain things, like I said before, we need to rely on others who have maybe more of a special degree or advanced placement in a position, but I really can't speak to what could or could not cause a fish kill in a given water body.
Okay. When you're saying the 50 soil samples, how deep are you guys testing those in?
Those are mostly, we could go right here, we can go to the data. I mean, it was mostly shallow samples within the first couple feet, which is where you'd expect to find either pesticides that were applied during operation or possibly historically. So it looks like the general depths went from the surface grade to about 2 to 2.5 feet below grade. And that's really, that sampling protocol is outlined in the New Jersey Department of Environmental Protection Historically Applied Pesticides Guidance document. They prescribe the frequency that you should test, the depths that you should look for, the analysis that you should perform, and that testing was performed in accordance with that guidance.
Okay. So a bit frustrated, but I have a question for the board. If I have neighbors that have had anomalies with some chemicals in their drinking water tests, what's the process for them to bring that forward? Who should they bring that to make you guys aware of it, if they want to make you aware of it?
Mr. Carr, Health Officer.
Mr. Carr? Have them come visit you?
Sure.
With their results?
Yeah.
Okay. All right. I think I am done.
Okay. Michael, you need a break, because I think we're about an hour and a half in. So we're going to recess for about 10 minutes. I can't see what any of the clocks say. What's this, 8:33?
Last time I brought a water bottle. I didn't bring a water bottle.
All right, so we'll reconvene at 8:45 to that clock. Okay, we're back in session. I think we're still comments from the public, or not comments from the, questions from the public, sorry. So if anyone else would like to come up, please state your name and address for the record, please. We got a lovely mic up here now that actually works.
Can I move that over here so I can lean my book on the top here? Is that okay?
They might not reach.
I don't think the cord's long enough.
I'll stand there. Tim Veracco, 3 Franklin Drive. I'll pick up on Mr. Linus's term, loose ends. I think I have some loose ends here. I'll start with a question to Mr. Latanzi. This notion of discontinuance of water testing, it came up in July. The initial meeting on this was in May with the Environmental Commission. Is there any reason this didn't come up in their presence, in the presence of Dr. Abrupta and those experts, as opposed to bringing it up here at the planning board? That seems to be their jurisdiction, so I'm puzzled by this, to bypass them.
Well, they don't really have jurisdiction. They're an advisory board, so.
Are they not the environmental experts?
No.
They are a group of people who have environmental experience, who give advice to the planning board and makes the ultimate decision.
Are there people on the planning board who have environmental expertise, LSRPs and so on?
Well, that's why we have an environmental commission to give us advice, and we have an engineer right here that's our degreed expert.
Okay. The original, can I address it maybe to you, Mr. Sirachi? The original 94 resolution obviously had a lot of input from the Environmental Commission, a lot of diligence, a lot of...
Calls for speculation. Mr. Veracco, could we ask a question?
Sure. There was a lot of input from that Environmental Commission, not the township attorney or whatever, and you would tend to think that if we're going to make a change, because there's nothing even in the resolution that says it's negotiable, but nonetheless, somebody decided it's negotiable.
Excuse me, is there a question to the
Yeah,
witness?
shouldn't they be party to this?
Is there a question to the witness? That's where we are.
Well, no, I addressed it to Mr. Sirachi, I said that.
Well,
Well, No, but I'm just going to say procedurally, no, the environmental commission doesn't need to be consulted.
Okay, can I ask a question to Mr. Carr? Or no? Simply his qualifications?
No, he's not a witness.
But he's weighing in with Mr. Hay on, this is a good thing to do. So wouldn't it be nice to know?
Mr. Veracco, the questions are for Mr. Latanzi. That's what you're up here for to ask. You've been before the board multiple times. You know.
Okay, a question on VOC exceedances. Hold on. For Mr. Latanzi. I have from the NJDEP a document that says toluene was detected, and pursuant to a May 26, 2022 letter, you're required, this is to RBG, you're required to submit a plan outlining procedures to identify the source of toluene in the discharge and how this substance will be eliminated from the waste stream. Mr. Latanzi, are you familiar with that? What can you tell us about it?
Mr. Carroll, why don't you show Mr. Latanzi the document you're referring to in the whole bit, so he can answer.
Sure. I'm not making this up.
No, I have not seen this before. Again, the permit that is pertaining to the septic system is typically monitored by another company, not mine. It's also under case management. The only thing that we have in terms of the resolution is that the septic system is going to be decommissioned, that we continue to do some monitoring to see if there's actually any groundwater in the wells. We've never actually seen water collected in the wells, and I think, I want to say something to the effect of that the sampling really isn't reflective of groundwater conditions. It was really collected from the actual system itself, from the actual septic, not from water, not from a well, because the wells are dry. So that's about the limit of my knowledge when it comes to this report.
All right, well, did you not make a blanket statement that there's no pollutants of any sort, no exceedances of any sort coming from the golf course that you're aware of? And now, does this tend to go in the face of what you said and perhaps raise some question of the whatever you will, the broadness of your statement?
Well, like I said before, this, with the detection of toluene, it was detected within the septic system, in the actual system. It's not it's basically an aliquot, a sample from within the system, not from an environmental medium. It's not from groundwater, because again, we've monitored the groundwater there. There's no water present in the shallow soil zone. So this is not something that is an exceedance from an environmental perspective or from a DEP standard.
Really? Double talk. A little bit of a repetitive question, but did you see anything in the resolution, anything in what Eco Sciences wrote, where it says that those testing requirements that were spelled out then were negotiable and had an end date, had a sunset date? On what merits did you feel you could bring up something like this, particularly also that you brought it up not to the Environmental Commission? How did this all go down? How do we think about this? What precipitated this? What gives you this leeway? Where do we lose our rights as in the community?
One question.
You're asking about 15 compound questions.
Okay.
I feel like I addressed those questions in the prior gentleman's questions, and also to the board about why we're modifying the plan, that we're updating it to be current with current DEP regulations, to fit the needs of the project. And again, we've had repeated data to show that there's been no effect. So I can't really speak to why it wasn't, if it wasn't discussed during the Environmental Commission or if it was discussed before the Planning Board. I don't think there's a rhyme or reason for that. It's not something that Royce Brook and I discussed, and then we implemented this plan for modification.
All right, last thing I'll go to Mr. Hay and yourself. I guess you could both maybe chime in on this. We know that the golf course, only Mr. Latanzi, okay. What if their storage facility where they store all these chemicals and they mix all these chemicals has a spill or a leak? What if that doesn't happen in the 5 years, but it happens after that? What protection do we have?
I really can't speak to a hypothetical of what may or may not occur at the property.
But is it a practical reality that you could have a spill or a leak? And they have bulk storage there, correct? And could it spill or leak? Could it go undetected? You can answer that, right? That's not hypothetical.
That is hypothetical.
Yeah, could it spill or leak? Yes or no? Could it spill or leak? Yes or no?
I think he's answered the question.
Yeah, I don't really understand. You're asking a hypothetical question about something that could or could not happen.
And it's a yes or no. It's a yes or no answer. Could it spill or leak? Yes or no?
Asked and answered. Thank you.
That's your answer, is that correct?
Mr. Bernstein, did they answer that question?
He answered it to the best of his ability.
He avoided it.
I don't really think it's a question I can answer.
Ultimately, Mr. Vaccaro, up to the board, what they want to do in terms of addressing length of time. As to asking a hypothetical that anything is possible, you know the answer is anything is possible. Whether or not having an extended testing period or not is going to prevent such from occurring is outside of this board's jurisdiction and really outside of even the resolution back to 1994.
Doesn't make sense what I just heard, I don't think, if I understood it. I don't think anybody said,
Mr. Vaccaro
Yeah.
has questions of the witness.
well, I'll close with just saying, we need people like Dr. Abrupta to weigh in on this.
That'll be afterwards, you can say that. It's only questions right now.
Doug Eden, 55 Ann Street. Mr. Latanzi, you made a comment that the Roycebrook Golf didn't know anything about the resolution prior to 2007?
That's correct. That's, as reported to be in my knowledge of the case.
No,
So they bought the property in 2007, so they didn't know about the resolution until 2019? Is that what your comment was?
That's correct.
Okay, so that's correct. So in 2019, who are you saying was negligent of not upholding the resolution?
You didn't say that.
I don't think I ever used the word negligent.
Mr. Vaccaro, you got to talk of the moment.
Sorry. I don't think I used the word negligent in my testimony.
So if there is no testing being done and the resolution was that there should have been testing, wouldn't that make somebody negligent?
I don't think it would be negligence. I think that they were not aware of the testing requirements, and as soon as they became aware of it, they acted immediately to rectify the situation.
So who should have been aware of it?
Certainly, when they made the sale or purchased the property, the seller should have at least advised them of the requirement, but that was not made at the time.
So was there testing prior to
Yeah.
this, to the ownership of Roycebrook Golf?
There was initial baseline testing that was performed as part of the 94 resolution. And
So after the baseline testing, there was no, to the best of your knowledge, there was no testing from 1994 until
it was more like, yeah, it was more like
2019?
It was like 98, yeah, 1998. Correct.
But it's a 1994 resolution.
Correct, and then the 94 resolution was there was a monitoring plan, then it was implemented, and there was letters from Eco Sciences dated, don't quote me on the month, but I believe it was in 1998.
So you're saying Roycebrook Golf, my point is, Roycebrook Golf shouldn't be held accountable for not taking tests from 2007 till 2009, because you're saying they didn't know anything about tests being taken that they should have been taken in the 1994 resolution. Is that correct?
That's a very long question.
I think he answered the question.
Yeah,
I don't think he did. I'm waiting for an answer.
Did
I
you
think
answer the question?
I believe I answered the question.
What
I
was your
mean,
answer?
I said, once they became aware of the resolution, they began sampling in accordance with the monitoring plan. I mean,
So before that, Roycebrook Golf owned the property from 2007 until 2019. They had test wells on the property that they had decommissioned and never asked anyone, never asked the DEP, they never asked the township, they never took it upon themselves to find out what those test wells were for?
No, I'm sorry, I wasn't there in 2007 to determine what was going on with Royce Brook. All I could say is that once they found out about the resolution, they moved forward quickly to rectify.
Okay, with that, I just want to read on a letter that was from February 10th, 2021, to Mr. Miami. You want to show the witness the letter? Sure.
Mhm. Who's this letter from? Let's see. Okay.
Okay. So could I? The letter is from Mr. Carr. And I'm just not going to read the whole letter because I don't want to take everybody's time. I'm just going to read the last paragraph.
What's the date of the letter, please?
I
What's
just
the date of the letter?
stated it was February 10th, 2021. It says, please provide written documentation that you have taken all necessary steps in order to be fully compliant with the prior planning board resolution for this property within 30 calendar days of this letter.
That's consistent.
Failure to meet the requirements set forth in this resolution and this correspondence could result in legal action and/or negatively impact future plans of the property. So you said they took quick reaction as soon as they found out about it in 2019. This says that you need, within 30 days, it could result in future plans future plans, impact future plans for the property. But it said within 30 days. When did you start doing your testing?
We started the testing in 2020.
And what testing did you start in 2020?
This testing that's outlined in the 94 resolution, the collection of groundwater sample, surface water samples, and gauging of the septic system monitoring wells.
And with what results?
The results showed no signs of pesticides or any other byproduct of the golf course above DEP standards. Also, the septic well, again, dry.
And when did you drill your well at MW6?
I couldn't tell you I have to go back to my reports to tell you the exact date it was installed.
You don't know when you installed
can't.
MW6?
I can't tell you the specific date, no.
Was it prior to 2019?
I couldn't, again, I'd have to go back to my reports.
Was it prior to this letter?
I asked an answer.
Was it within 30 days of this letter?
Again, I don't have that information in front of me. I mean, all I could say, the well was installed and it's there. It's in accordance with DEP requirements. There was a well permit filed to install it, and it's been installed in the proper location, and then was continually sampled over time.
And then when did you just finally put in the 120-foot well?
We put that. Well, I know that one because that's more recent, right? That and in the recent report that was installed in October 2023.
You also made a statement that the septic system for the clubhouse and the maintenance area is going to be hooked up to city water, or being hooked up. It's going to be, I guess it'll fall under the wastewater management plan. So I guess they're going to actually hook up, and they're going to do away with the septic systems in the clubhouse and the maintenance house?
I can't speak to the buildings, but I do know that the septic systems will be decommissioned. That work will be discussed with the department to make sure that it follows their regulations, and then the corresponding monitoring wells that surround the septic systems will be decommissioned. That's about the extent of my knowledge on the septic system.
Isn't that where most of the violations were found, within the septic systems?
Which violations are you speaking to?
VOC violations in the past? DEP?
Right, I just spoke to those in the last line of questioning.
But was that where they were found?
Yes.
Okay. So, Mike, I guess what I want to know is, what I was told was that the property that is going to be sold off to Toll Brothers, which is what's going to be built on, was put on the wastewater management plan. I wasn't aware that the property by the clubhouse or the maintenance building, which is the remaining portion of the golf course, was actually on the wastewater management plan. Could somebody tell me when that happened?
Oh, that's not part of my testimony. I'm really here just to speak about the 94 resolution. I'm not here to talk about the construction.
But you made the comment that they're going to eventually put the clubhouse, I guess the septic systems are going to go into city water. Well,
Right, because
I guess they would have to be on the wastewater management plan to be able to put
just-
that into the sewer system. And
Simply informing the planning board that those systems are going to be decommissioned, and then, of course, the property is going to be hooked up to city services. It was just a simple statement. That's about the extent of my knowledge of the former septics, or what will be the former septics. So I can't really
well, I
answer
don't
your...
understand how that could happen if it's not on a wastewater management plan.
We're really getting into the weeds here that I don't know. I'm telling you that I'm not here to answer questions about the construction. It was a simple statement that, again, septic systems will be decommissioned. If you don't have a septic system, of course, you're going to need something else. I'm simply saying that the connection was going to be planned for the future construction.
Well, my concern is the VOC violations that were in those areas in the past that you're going to be decommission the wells in the area, so there will be no further testing. So that's my concern. Once the property's turned over and sold off, I guess in the near future to Toll Brothers, who's going to be responsible for the testing? Because going 5 years forward, if that property is no longer owned by Roycebrook Golf, then who's going to be responsible for that?
A portion of the property will no longer be owned by Roycebrook Golf. A portion of the property will remain being owned by Roycebrook Golf. That's the application that this board approved about a year ago relative to the building on half the site. So the ownership hasn't changed any.
Thanks for clarifying that for me. But so where the test well is at this moment is going to remain Roycebrook Golf property?
Yep.
Okay. I appreciate that. So I guess Roycebrook's coming before us today, and you're asking to...
Roycebrook's coming before the board, Mr. Eaton.
They're coming before everyone. I'm here, so I'm making myself part of it. Sorry, I'm coming before the board. So you guys are coming, and you understand my position here. I was at the meeting in 1994, and I was concerned about a golf course that was going to be 36 holes, the chemicals, my water system, my well water, my drinking. The township heard us. They put together a resolution. So here goes 30 years later, 2019, I make a phone call. I say, hey, guys, let's go back a little further. I see Dr. Belney. Dr. Belney, how's this going? How's the testing going?
Is there a question?
Yes, it is. I'm leading up to the question.
No,
Give me a second.
don't lead up to it with hearsay testimony about a conversation you may or may not have had with Dr. Belney. Ask the question of the individual related to his testimony.
How the hell could you come before a board and come before the public in full honesty and just say, we didn't do any testing, we didn't test your wells, we dropped the ball, and now we did a test within a year or two, and we did a couple of tests, the 120-foot well, we did one test, and you know what, Hillsborough Township, can we have a break? Because this is getting to be too much for us. So how could you come up and ask that? I could understand asking that question if you said we monitored and tested these wells for 30 years and we've had no issues. Now, could we going forward, can we stop testing within the next year or two after construction. That to me makes sense.
Is there a question to that?
Yes.
What's the question?
How could you come before the board with asking for this, for this leniency? It makes no sense, because even with your professionalism, it hasn't been done
Would you
for...
let him answer the question?
No, let me finish talking. Don't interrupt me, sir.
What is the question? What is the question?
How could you come before this board and ask for
Let him answer.
leniency for Roycebrook Golf?
As detailed, we have repeated data that shows that the golf course operations have not impacted the environmental quality on or adjacent to the site. Okay, we're actually, the sampling that we're performing and intending to continue to perform goes way beyond what the department would typically require for a site. Okay, we feel that this is protective, and we feel that the results show that.
So the one test that you took in a 120-foot well, you feel is sufficient?
If you listen to the testimony that was provided and what Mr. Hay also recommended, that's going to be repeated 9 more times over the next 5 years.
So if anyone in our community, in our neighborhood, has issues with their well going forward, you feel that Roycebrook Golf has no responsibility?
Issues such as environmental, mechanical, it's very vague in terms of issues.
No, we're talking about well waters. We're talking about well water systems. I'm not talking about mechanical.
Again, that's you're coming up with a hypothetical question.
It's not hypothetical.
You're saying if something's going to happen, that's a hypothetical.
Well, what I'm saying is, if your one well that's 120 feet deep,
Mhm.
if there's well issues in our area, even though your testing well is showing that there's nothing in your well, it's showing that there's no violations, but we're having issues in our area, could that be directly related to the Roycebrook property, where we're getting our well water from? I mean, would that one well detect all contaminants that's coming into, 200 homes?
The 94 resolution recommended a well in that location. We're simply following the resolution as it was stated. That's what we're looking to follow. So if you were there in 94, Eagle Sciences made that recommendation, the wells were installed in these locations, that's what we're following.
Could there have been issues in the past, within the past 30 years? Could there have been contaminants getting into the well water and now they're not being detected?
Again, that's a hypothetical question. If you look at the data, though, overwhelmingly, it suggests that nothing has occurred in terms of the environment.
Over one test?
No, we have multiple tests.
No, I'm talking about the 120-foot well, which mirrors our wells.
It's one test, but it shows that there's nothing detected. And if in prior testimony I've said, even the deeper well, I didn't think was as appropriate as the more shallow well, because again, if you understand the science of how things could migrate through the ground and into the groundwater, the shallower well actually performs that function much more appropriately than the deeper well. And the shallower well, we have at least 6 events over the last several years, and we have not detected any pesticides or anything from the golf course in the well. So we do feel that the well systems are currently and will be protective to evaluate future conditions.
Okay. I have nothing else. Thank you.
Thank you.
Any other members from the public? You're the last member of the public, so that's why I was looking at you.
Figured I was waiting to make a suspenseful moment. All right. My name is Anthony Gallupo. I am from 44 Franklin Drive, part of the neighborhood that backs up to the golf course. One question I have is, if the record keeping and the testing only started in 17, If the golf course monitored and/or lowered the amount of pesticides that they use and everything else, knowing that testing has now begun, are there any records regarding the amount of pesticides that were applied, whether it was the amount of pesticides that were purchased in the past versus what's now? Is there any way to relate what they're using now and what the test results are presenting versus what could have been used in the past and what those levels would have been just based on the current conditions? Is there a way that for you to understand, like, is that part of your investigation? And I apologize for the compound question, but I just want to give you more details so you can answer
Right.
it a little bit more accurately. But is there a way for you to determine what was used in the past versus now, whether it be a form of a log or purchase or something to that effect, so that we can make a determination as to what it is now and what was occurring in the past?
Well, the testing that's been performed is a wide suite of parameters. They range from historic pesticides that may have been applied to more current ones that can have been applied at the site. And those, we have collected those samples and tested for those parameters. And there, again, there's usually a suite in a set list. So we've tested for what is regulated by the DEP for pesticides. That's what I could answer to that.
Okay. So I guess the biggest point of that is going to come back to, you have the ability to determine what was used throughout that period of time, correct? Meaning pesticide, poison control, weed control, all of those chemicals that were laid down. Is there a log that determines or is held by the golf course that would say, here's what was used during that calendar year?
I can't speak to what the operators gather in terms of records, to be honest. That's a little bit out of my expertise there. I haven't seen the law. They could be. I haven't seen. It's really outside of what I'm looking to do here for the resolution.
Okay. The last question I have is, when you talk about, the gentleman, Mr. Peason, had said something as well, but when you talk to the effect of an aberration in the results, or an abnormality is the word that was used, what would that consider? What would you consider in those test results an abnormality? And can I give you a little bit more detail beforehand? Meaning, technically, when you're saying an abnormality, that means that there might be a test result that was higher than it should have been, but then subsequent testing, for example, proved that incorrect or a one-time thing. Are you?
That, it could be that, it could be, or vice versa. It could be something that's typically shown something that was higher that is now lower, and that data could fluctuate. And that's why we spoke before about repeated data to show a consistent trend and to make sure that if there is an anomaly or anomalous detection, whether it be due to reporting or sample collection methods, that we verify it through additional sampling.
Well, the reason I ask that is because when you say things like abnormality or a higher test result than what it was, what that means is that somebody was drinking water that may not have been 100% healthy for them. Whether you're talking about an eyedropper full, if I put a glass of water in front of everybody at this and said, here's a poison, but it's only a small drop for you, it shouldn't kill you. When you talk about circumstances like that, you understand why there's either a tension in the room or why we're trying to get answers from you on that, because there's a bigger concept as to whether or not if the testing, if people have already gotten sick, there's no recourse. So I guess I apologize, it's a little bit off key here, but understand when words are used in these type of things that for your personal, professional opinion, okay, there are people involved. That's all I want you to understand, and that's all I'll say, is that it isn't, when you're talking about, I'm leaving, when you're talking about poisoning people, when you're talking about that, it's, there's a little bit more to say to that, and I don't want to get into any further battles or not follow procedure, but I just want you all to know that as well.
Any further questions? Okay. Motion to close?
As is, we might as well leave it open because we're going to end up with the public portion.
Okay.
Can I bring up mine?
A question?
Yes, it's a question, and it should be something that the witness should be able to answer pretty easily. Great, thank you. It's a very specific question. Tom O'Donnell, 33.
Come to the microphone,
Sure,
Mr.
sure.
O'Donnell.
Tom O'Donnell, 33 Ann Street. In your document that you provided, there is a pesticide schedule. Are you familiar with it? It's like green, a whole bunch of color codes with the different chemicals.
Which report are you
It's,
referring to?
I think it's a pesticide calendar schedule. And it goes through, it's an Excel spreadsheet, and it starts, I believe, in October, it starts in May, and it ends in October. And in my head, I had a question like, is that complete? Because I live behind the golf course, and I could tell you this morning, they were spraying something. And we're now in November.
Testimony, just ask the question.
Sorry. Question is that complete, that document?
Well, don't you need to see the document? I mean, what document?
So you're,
It's in your packet.
just to
I mean,
clarify.
I didn't type out
you're
143 pages.
You're asking why we're sampling in June and October?
No.
Okay.
I'm
see,
specifically
I'm
saying,
lost.
you provide in your packet, there's a
Okay.
calendar for pesticides application. It lists all the pesticides being applied throughout the year. And the first record on that spreadsheet is May, and the last record on that spreadsheet is October.
I think.
Where's the rest of the year?
Excuse me, I think in fairness to the witness, the gentleman should produce the document that he's referring to. There's plenty of documents.
He's trying to describe it. Do you recollect seeing a schedule?
No. I don't recollect seeing the schedule. I could also say that the sampling follows the 94 resolution for testing in June and October. We're mirroring the 94 resolution. We're keeping consistent with what its initial intent was.
I don't know how to respond to that. I'm trying to clarify something that's in the packet, that's part of the topic tonight. It's in there, and it
Yep.
seems incomplete, and it lists,
I found it.
okay, and it lists actual pesticides.
It's-
So
I'm
why
gonna
is
just-
it only from May to October?
It's actually dated August of this year. It's called RBG for Ref 18, Chemical and Fertilizer Application Log 2022.
Right.
I see it, I'm sitting
Thank you.
clerk right now, so. At least
And
it
you,
was.
and you can see the first record is like May
Now
something,
you're
and the
asking
last
for-
is
It's an eye
October.
chart, so.
It's, yeah, it's pretty
I
tiny,
need to zoom in, but
but,
lots of blue and green in there, so.
right.
It's a-
But to be fair, Mr. Donald, they do chemicals, you're allowed to do by DEP standards to apply up to December 1st. So the resolution back in 1994 put the dates, as the LSRP said, in May and October, and that was the dates that, obviously, during the periods of time that they test. That's what.
So the
94
packet was
resolution.
adjusted to reflect the dates in the original resolution?
This
Because it was
doesn't-
asking for
this-
June and October testing.
This isn't a test, it's a application, a
right.
chemical log.
Right.
I don't think it was provided by the witness. It was provided by Royce Brook Golf Course, I would
Well, it's
assume.
part of the application.
It's
Yeah.
part of the documents that you guys are basing your decision on, right? And Mr. Hayes has looked at, I'm sure, like the pesticides to get an idea of what's in there. I'm just saying that it seems incomplete.
I'm just gonna, did you look at this log as part of doing your?
I didn't
analysis?
review it in detail. All I could say is that, like I keep saying, the sampling, we're trying to mirror the 94 resolution
I get it.
for monitoring, right? We feel that that's appropriate given when they apply, right, in the summertime, and then towards the end of the season. We're trying to, usually you don't want to take samples too close to each other, right? You want seasonality, you want changes in groundwater conditions, you want to make sure you're accounting for fluctuations, and typically, when you're taking samples, it is by quarter, or it's by something longer than a quarter, or more than 90 days, so that you can develop trends and look at data appropriately. So we agree with the initial 94 resolution, where it should be June and October, and that's what we're proposing in our plan.
Okay. I get it. We're sticking to the plan. The documents, if they're not really, if I can't ask about the documents, then why are they in the packet? That's my question, more so to Mr. Bernstein. Like, if I can't ask him about the document, why is it there?
The issue, Mr. O'Donnell, is you can ask him. If he can't answer the question, he can't answer the question. He's not required to have memorized every document in the packet, nor is he required to know every document in the packet.
Okay.
If you want him to review a document, it's your obligation to bring it to his attention, not have the board come here and start looking through its civic pack as to which one you want to do. But let's assume you gave him a document, he looked at the document, he says, I'm not aware of this document and/or I'm not responsible for this document. That's the answer.
So why is the document in the packet?
Because it was provided as part of the overall record. That doesn't mean the witness is responsible for every document in the packet.
But the packet is there for us to review and ask questions about, correct?
Right, and if the witness can answer the question, he can answer it. If he can't answer the question, he can't answer the question. It's
So
ultimately up to
is it reasonable to ask, okay, this witness doesn't know this document is provided, that we could find out the details if that document is incomplete or not?
Mr. Linus?
I'm going to ask Mr. Linus, do you have a witness that can testify or provide commentary on this log?
Otherwise,
I
by the
don't
way,
even
that
know what
document...
document we're talking about at this point. There's
Well,
I
you
think
provided it.
if you go on the Civic website,
It's-
there's probably
It
100
was,
something documents.
well, I found it in a matter of minutes, not even, so.
Well, you can
It's a
make
new
ref-
document that was submitted since the last time you were here, so do you have a log of documents that you've mailed into the township?
Again, I'd like to see the document we're referring to.
Okay. Oh, you want my laptop?
Yeah, I mean,
It's right
you
here.
provided the documents.
What's the document?
I took the time to read
Mr.
443 pages.
Mr. O'Donnell, the board's asking the planning director to provide a laptop for Mr. Linus to respond to.
Perfect.
You don't need to respond.
Well, Mr. Linus likes to be sarcastic, so.
I
warranted a response.
need you not to clutter the record either with your comments. Everybody's comments are cluttering the record and have no value to this board.
Take a look at the document. If you can answer the question, you can answer it. If you can't, you can't.
Okay, so this one.
That's the one.
Yeah, so we could say the name of it.
Well, I did already, but he doesn't, you gotta show it to him.
Got
See
it.
if he's got a witness to speak to it.
Down the bottom. Eric, I'll put it in the
Yeah.
Thank you.
And I could show you. So, this one, RPG for reference 19,
Okay, good.
NSU letter. Oh, no, wait, I'm sorry. I think it's this one. It moved while I was coming down.
Guys, you're on, you're good.
That's it.
Your mics
That's
are
it.
on.
Mics are hot, and his fingers are moving, so.
And more importantly, the man
First look
whose
at the document, then
fingers
they'll
are
ask the
on
question.
is the problem child here.
Okay. Okay.
Okay, would you like to ask the witness a question?
Yes. Having looked at that document, is that document a complete calendar representation of the pesticides being applied to the golf course?
I cannot answer that. I'm not familiar with the full operations of an inventory of Royce Brook. Like I said before, the analysis that we do is broad. It's for parameters that are regulated by the DEP. As said before, the pesticide application is regulated by the DEP, and that's what we're testing to see if there is any effect.
Gotcha. When this started, Mr. Bernstein, did I not hear that Mr. Manami is here from RBG to answer questions to them.
No, Mr. Manami is here. It's up to Mr. Linus and/or the board whether they want to call, whether they want to hear from Mr. Manami. I know you all want to hear from Mr. Manami, but that doesn't mean the applicant is required to call him or the board wants to hear from him.
I mean, this was a document that was presented to you guys to help you with your decision process.
And from what I understand, it's not a document that Mr. Manami is the drafter of either.
Okay.
Any other questions, Mr. O'Donnell, of this
The
witness?
last one, it's related to my previous one. Is it possible to get clarification on where the bucket test is drawn from the property?
The location is provided on the plan.
Guy talking to the mic.
Sorry,
so it's in.
sorry. Appreciate it. Thank you. Sorry, Mr. Bernstein. My apologies. Here, it's located on several maps.
I see the dot, but I'm looking for more
Right.
clarification of, is it like in the woods, are you talking about, because that's going to tell me like the likelihood of water being there, based on my personal knowledge of that property.
I mean, it's in a wooded area. The sample is collected. It's collected as it's migrating, as the surface water is moving off property to the east.
For the record, what document are you referring to?
Well, there's in multiple locations. The October 18th, 2023 proposed
Which has been marked as?
A6 shows the location of surface water sample SW1, which is at the southeast portion of the property.
That's a shallow well.
Which
I'm talking about the
Which I
bucket.
believe, Mr. O'Donnell, correct me if I'm wrong, you asked multiple questions about in terms of how he was handling the bucket list for the purpose of testimony, and the witness testified as the same. Is there anything new you're going to ask?
Well, shallow well 1 is not where the bucket was deposited.
Okay, so now
Was it put in the well to get the water? Or is it collected from the actual ground? That's your well?
No, that's a surface water sample.
Oh, that's a surface well?
Yeah, SW surface water, MW6, monitoring well 6, monitoring well 6D. That is a point that's in the ground. This is collected from, either standing water or flowing water. That's that location.
Potable water.
So when you say bucket sample, what I was saying before to the mayor about how you collect a sample, sometimes, if you can't, you're not jumping in the water, right? You're reaching out with a sampler. It typically looks like a cup, and you collect the sample from it. It's on the edge of a stick. Then you retrieve it back. You take the cup, you pour it into a glass, and then you send that glassware to the lab for analysis. That's how you collect a surface water sample. So that's SW1. That's why I thought you were talking about that. It seems like you may have been talking about the monitoring wells.
No, I apologize. I
Sure.
thought SW1, Mr. Bernstein, I thought SW meant shallow well.
Oh,
I
okay.
didn't realize that it means.
I could see that too. Okay.
Stormwater collection point.
Right.
So it's obviously deep in the woods and it's behind my neighbor's house. I know. where-
Okay.
All right, I can take a look at that. Thank you.
You're welcome.
Public, unless Mr. Linus has any other witnesses, Mr. Chairman.
The applicant rests.
Okay. Sorry.
Public.
Yep. So now the public, you can come back up and state your opinion of this. Please be careful not to testify or provide any type of testimony, but you can now state your concerns or, I don't know,
Opinion.
opinions, opine on this application.
Okay, Tim Veraco, 3 Franklin Drive. Let me just close it out with, if I may, merge together, because I've been to a lot of meetings, starting with Toll Brothers, and then this water monitoring. And if you go to the Toll Brothers, water monitoring was a big question. And what came about was a member of the community asked about the well monitoring and had it been done and so on. Mr. Hoff, and I'm reading now out of the transcript, Mr. Hoff responded that the applicant had supplied monitoring data a year ago, which was satisfactory, and that he understood that the golf course had complied with testing as well. Well, that's a misrepresentation because there was a 35-foot well, not a 120-foot well, and so on. Next after that, our town engineer, Mr. DeCessa, confirmed they looked at the data, monitoring wells were installed, and the results were satisfactory.
Mr. Vaccaro?
Yes.
You're talking about an application not before this board.
Well, it's all part of it.
No, it's not all part of it.
What I'm trying to get at is...
No, it's not all part of it, and you have been up here before attempting to do the end around. Deal with the application before this board, not a previous application this board has already approved,
All right,
has been certified and the like.
Where I'm trying to go is, how can we in the community and the public be comfortable when these kind of things go on? And there's another false testimony that I could read out of the transcript. How are we supposed to go? And bring it to today, how can we be comfortable when the Dr. Abruptas and his colleagues are not involved? And you can't tell me Mr. Carr's credentials even, and him and Mr. Hay have teamed up.
Mr. Carr is
you know.
is the township health officer. He will be the resource if you have any future.
Can you tell me, does he have Dr. Abrupta kind of credentials?
Mr. Vaccaro, Dr. Abrupta has no official position with the Township of Hillsborough. Dr. Abrupta is a member of the Environmental Commission, which is an advisory board. Dr. Abrupta's opinions are Dr. Abrupta's opinions, having absolutely nothing whatsoever to do with the Township of Hillsborough. If there are issues involving these applications, they don't go to a Dr. Abrupta, and they don't go to the Environmental Commission. They come to Mr. Carr and the Township. So Dr. Abrupta's qualifications or Mr. Carr's qualifications are not at issue here. If there are problems, as you are well aware, you have the right to bring them to the township through Mr. Carr, Mr. Ferrara, or Mr. Coyce. And at that point, they are addressed. But Dr. Abrupta isn't going to address them, nor is the Environmental Commission, for this application or any other application that appears before this board.
Last thing. I have in front of me a letter from Mr. Carr to Mr. Manami dated April 18, 2022. The letter is 3 or 4 pages long, and it's very, very incisive, talking about problems, NJDEP problems, Najipti's problems, a lot of non-compliance stuff. He highlights non-compliance with the resolution, and then moving forward, a lot of conviction kind of strong statements, what RBG needs to do. They haven't done it, and now they're looking for a get-out-of-jail-free card. Why the sudden turnabout? How come you guys are on our side? You're trying to get the right stuff done. Today we're here, it's like, flush it all down the toilet, it doesn't count anymore. It doesn't make any sense.
Because, Mr. Vaccaro, one, this is an application by Roycebrook Golf to this board. The township's position hasn't changed any that I'm aware, but more importantly, the board's not an issue position. This is an application seeking relief from the prior resolution of the planning board by the applicant. It's up to the planning board whether or not they want to grant such relief, and if so, in what manner. That's what we're here for.
Well, Mr. Carr is here as a witness.
No, Mr. Carr is not here as a witness.
As an expert, whatever he's here as.
Mr. Carr is here, actually, at my request, Mr. Carr is here because he's the health officer, and the anticipation was that at some point we were going to have these discussions.
Okay.
Mr. Carr has commented on it, and Mr. Carr will have to deal with whatever the board decides to do.
His position tonight is 180 different than the letter.
Mr. Carr has taken no position on this, except to make recommendations related to the If Mr. Carr ultimately is required to do other things, Mr. Carr will do other things. It's up to the board at this point whether to grant the relief.
I think there's credibility problems.
Doug Eden, 55 Ann Street. Again, this resolution was put into place to look out for our health and well-being for the public. I don't know where the ball was dropped, but for 30 years, it was ignored. We never had the testing. Who knows what health issues we're at risk? I mean, who knows what happened over those 30 years? What was in our well water? Just like now, what could be in the well water today? Maybe last week it was there, this week it's not, last month it was there. Last year, maybe there was higher amounts. 10 years ago, maybe there's higher amounts. We have no idea. We have no idea what's been in our well water for 30 years. The whole time, I felt, others that I know in my area, in my general vicinity, we all felt that we were being watched out for by the township, by our health officials, and Roycebrook Golf was doing their due diligence. If I didn't send an email to Mr. Ferreira in 2019 asking for results, we probably wouldn't even be here right now and talking about this. It would have been probably swept to the wayside. So I don't know where the disconnect was, and that's what my question was to the LSRP. I'm sorry, I don't remember your name, but that's why I wanted to know, who did he feel was negligent? What happened? In 1994, I mean, did the prior owner do tests? I was told that there was tests being taken from the time early on. And now 30 years have gone by. Like the gentleman over there said, who knows what's been in our water? And there's been people that have had issues. So going forward, if we're going to have issues, and there's going to be no one to be held accountable, because you guys are going to say, hey, guess what? We didn't see anything within the last couple of years. But they're going to do construction. They're going to disrupt the soils. And there's not going to be anybody held accountable because Roycebrook feels, hey, guess what, guys? Hillsborough didn't enforce it. Nobody told us. The title search didn't show anything. What else was I told? We were never made aware of it. It's a disgrace. This is embarrassing. I don't understand how this could have happened. And however we go forward from here, obviously, there's nothing that I can do about it. It's all up to you guys. But to give them a pass, I feel that we need to continue to do testing. Since you didn't do it for 30 years and we were put at risk for all that time, and God forbid, who knows what could have happened with people's health in that amount of time, people's kids. So I'll leave it at that.
Tom O'Donnell, 33 N Street. I echo the sentiment of Doug Eden. He's a good friend of mine and a neighbor. And, as the board knows, we're not too happy with some of the things that have been proposed on this property. And then finding out just because Doug asked for results, I personally think he's right. If Doug didn't ask for those results, we wouldn't be here. Like, this never would have been addressed, which is even a worse atrocity. I think, personally, my opinion, I think that we've done good things, got the deeper wells. The sentiment of this meeting is quite different than the last one. I mean, the last meeting, Mr. Bernstein even called out, oh, so you dug an illegal well on the property. I don't know if everyone had a great vacation or, had a good time, but we're in a 180-degree experience here from our perspective as homeowners, as residents and taxpayers. And if there's any give, fine, potentially, but to basically say, oh, we're good after the 3 years more for the groundwater and 5 years for the one deep well that's just been dug after the neighborhood's been potentially exposed and put at risk for 30 years, I think that's not equity. There isn't equity in that. I mean, I personally have raised 3 daughters in this house. My oldest daughter was 5 when I moved in. My second and my third daughter were born in this house. How would I know as a father that they're not going to get sick, God forbid, with some disease 20 years from now? That bothers me, and there are now people with babies, like that next generation of homeowners in the community. There's like a whole nother group with, like, I think about when my wife and I moved in almost 30 years ago. The least you can do is protect those babies. And to put a cap on it so that Roycebrook can save their money and not have to pay, and it won't even be Roycebrook, or maybe it will, it might be Toll Brothers, but to put a cap on the term to save the landowner money and potentially put additional babies at risk that are now living in our community, that's wrong.
Anyone else from the public? Okay. Motion to close?
So moved.
Second.
All in favor?
Aye.
Wishes of the board. You've heard the request of the applicants. You've heard comments from the board's engineer and the township health officer. Board can agree with the recommendations, board can modify the recommendations, board can refuse the recommendations. Your calls.
Any deliberation? Thoughts?
I'll start off because, God forbid, I've never talked in public before. First of all, we are looking out for you. And I don't know what happened between 1994 and now, and we can't fix what was done 20 years ago. All we can do is look forward and move forward. The well testing that is being done now has been modified to a depth that the request that you made. We are obviously aware of the resolution, both with the current owner of Roycebrook and the potential tenant of the property. They're sitting with us. It's obviously going to be memorialized. It's going to be addressed between both our professionals and engineer and health officer. So I'm pretty confident that it's not going to get lost moving forward. We have 2 protection levels, one that has been instituted in more recent time than when this original resolution was done in '94, that every house sold in your development will have to have a mandatory water test. So that acts as a personal protection to you, because if something should come up, we would become aware of it. If by chance, even if the results of our own water test here, whether it went for 5 years, 10 years, whatever, should show, that is still a level of protection. But that being said, I see some time to rectify and heal here, whether it's the law of the DEP or our esteemed LSRP in his opinion. We're talking about 2 wells that we're testing, correct? Not 100, not 50, 2. I would think that in good faith that we could extend this time of testing to 10 years. And at that point, we would then have our engineering company, whoever it would be 10 years from now, we would hope it would be Pannoni, but we'll just say whoever our engineer is, would make a recommendation in conjunction with our health department that they have seen a significant data sample to allow the testing to stop. So I think that alleviates and rectifies some of the past wrongs and gives some comfort to the residents who live by through the construction that's going to be done, the post-construction period, and a significant data sample to provide the residents of Hillsborough. If the applicant would be agree to that, I would move forward with that proposal.
So I was just going to maybe amend that just slightly, but I think I'm aligned with the mayor's thoughts, but I know the next question is how long construction could take, and so I'm just thinking maybe to preface that with 10 years or 5 years, at least 5 years after construction's completed, whichever's longer. I think that's right.
I'm okay with that.
I think that's the right term, right? I think along those
Whichever's
lines.
shorter?
No, or longer, whichever's longer. It's minimum 10, it could be longer, once we hit 5 years post-construction.
And you'll have to define
The last
what post-construction means.
means the last CO's been issued.
Last certificate of occupancy granted by the township for the Toll Brothers, for the RBG Enclave project.
Correct.
Thank you.
I would move that motion forward.
Is there any other comments? Just,
Yeah, I would just agree with both of your comments. We can't redo history. Whatever happened, I certainly wasn't involved in back in '94. I just moved into town at that point. So we can't change what happened for the last 30 years. I would assume that if there was a well water contamination issue that would have been brought to the attention of the Department of Health, that information would have been brought to us now in connection with this request, but we don't have any of that information. So I have to assume that since we don't have it, that nobody in the community has provided to the town or come to the town and said, hey, we've had a problem, and somebody would investigate and find out maybe sooner that the testing wasn't done. But I do agree that extending the time and tying it to the end of the construction with the issuance of the CO is an appropriate compromise. It may be longer than what the applicant wants, clearly going to be more than another 3 years or 5 years, but it certainly seems reasonable.
Is there a chance I could just?
No, you're done.
Upfront
You're
say
done.
something to what Mr. Lepani said, because it's not right.
Nope.
He said about homeowner well testing, it's not right.
Mr. Vaccaro, you're done, okay? Well, let's move forward with the process.
Facts right.
Let's, enough,
What you said is wrong.
okay? I'm trying to help you out.
Herbicides and
I'm trying to help you out here. Relax.
That's not helping. Pesticides and herbicides are not part of well testing when you buy a home.
Mr. Chairman, the issue before this board is this applicant and the requirements for testing. As to other requirements for testing, as to other property owners and the like, it's not before this board. And whether the mayor's comment that there is well testing available is a separate issue, because the applicant's never been required to test on anybody's property all along. So there's a motion, I don't know if there's a second. The motion is to approve the change in the well testing into the testing requirements as per the recommendations of both Mr. Hay on behalf of Pannoni and Mr. Carr as the health officer for a period of at least either 5 years from the final granting of a certificate of occupancy by the township for the RBG Enclave property, or 10 years from the memorialization resolution by this board, whichever is later.
Okay, so I think the mayor made that motion,
Need a second?
Yes.
I'd second it.
okay?
Might I make a comment? I want to hear what the motion is all about, because I don't believe that it's fair to have the applicant wait for construction of another applicant to have this thing accomplished. In other words, Toll Brothers, I understand, has a separate application.
Toll Brothers has been approved to move forward. If the applicant is not happy with the time frame, the applicant has options available to it. Does it not, Mr. Linus?
That's true, we could appeal.
That is correct. So your call, but that's what the board's willing to do, to ostensibly address the fact that it's been nearly 30 years as to what should or should not have been done. And since, as Mr. Radowitz and the mayor and the chairman and the board have indicated, we can't put the genie back in the proverbial bottle again. We are trying to deal with this going forward. If your client's not happy with the provisions going forward, he has options available to him. But frankly, just for the record, two pieces. In spite of the fact that the governor announced the nominations of 3 people today for judgeships in Somerset, nothing's going to move too fast, as you are well aware of, for civil trials.
I am well aware of that.
Item number 2, the fact is that I believe it has an impact on other things going forward, so it probably behooves everybody to get this thing moving forward.
So my question is,
The question is,
motion?
the motion is to approve the testing requirements as set forth in the Pannoni and the Carr letters. And the testing is to go on and the results to be provided to the township for a period of 5 years post-final certificate of occupancy being granted by the RBG on Clay property, or 10 years from the board's resolution of memorialization, whichever is later.
Mr. Bernstein, can I just ask one question?
Yep.
Can we make the requirement of testing to run with the land and not the applicant? So that if the applicant transfers ownership of the property, which sounds like it may be contemplated to be done prior to the expiration of the period of time.
Any and all future property owners of the site will be bound by this requirement.
So it would run with the land.
Run with the land.
Okay, so I'm going to ask the mayor.
And the obligation, by the way, of future property to be filed with any and all paperwork and proof to the township that any transfer of ownership relative to this property, that there is an acknowledgement by the subsequent owner or owners that they are aware of this planning board resolution.
Okay, I'm going to ask the mayor to remake the motion on the amendment.
I make the motion with the amendment stated by Mr. Radowitz and Mr. Bernstein.
Mr. Radowitz, do you second that?
I second that.
Thank you. Okay, we have a motion and a second. Any final deliberations of the board? Okay, hearing none, I'm going to ask for a roll call.
Mr. Beeson?
Yes.
Ms. Smith?
Yes.
Mr. Radowitz?
Yes.
Mayor Lapani?
Yes.
Chair Sarachi?
Yes.
Thank you.
Thank you. Okay, just a reminder, we don't have any other meetings until December 14th, which will be our final meeting of the year.
And our favorite subject will be back on the agenda.
Okay. And that will be
Sorry.
on or about starting at 7 PM on December 14th. So with that, I will entertain a
One quick informational item for any of you who have the burning desire, who are down at the league next week. I will be on a panel from the New Jersey planning officials talking about warehousing and light industrial uses, because I have no expertise whatsoever in the concept.
Okay, there's a shameless plug.
At the convention center at the New Jersey.
You really had nothing else to do but put more things in your eyes and ears.
When is that?
Wednesday at 2 o'clock.
Motion to adjourn.
Second.
All in favor?
Aye.
Aye, everyone have a great Thanksgiving holiday.